morning, everybody. Happy Tuesday. Welcome to the Courtroom Files Live. We will start our day in Michigan with Judge Simpson, a.k.a. Judge Bond Continues, and see what's going on in his courtroom.
A conflict exists in this honorable court hearing these matters. If a conflict were to arise, we would waive such conflict so that this honorable court could hear these matters.
Thank you, sir. And the court, for its part, does not believe there's conflict either in the Michigan court rules or the cases decided thereunder. To the extent a conflict does exist, given the waivers, the court will consent to hear the matters. Court does call the case of People versus Valerie Johnson. Got her.
Joseph Development of People, Your Honor.
Assistant Public Defender Hannah Apple appearing on behalf of Ms. Johnson. Ms. Johnson, can you state your name for the record?
Valerie Johnson.
Your Honor, I have an application pending to schedule a meeting with Ms. Johnson, so I'd ask for an adjournment for that purpose.
Without objection. How much time? You have the application.
The application is pending, but I already have, I guess, my video visits approved. So once, it shouldn't be very long, I think. That makes sense.
Okay. I believe that. All right. Probable cause conference will be here on September 4th.
Thank you.
2025, 9 a.m. Bond will continue. Thank you, Ms. Johnson.
Thank you.
Senator Greg here.
Court. Really? No, go ahead. I'll wait. You got everybody? Court does call the case of the People versus Michelle Lovaz.
Scott Shea, Your Honor, with and on behalf of Ms. Labaz, who's approaching.
Morning, what's your name?
State your name for the record.
Michelle Labaz.
Thank you. All right, what are you doing?
Your Honor, the defense has been awaiting supplemental medical records for quite some time. Medical records take a long time to obtain. My understanding is the prosecutor's office has them. They will be tendering them to us. We will be tendering them to others who need to review them. I'm going to be out of the country between August 31st and September 19th, so we're requesting a PCC until after that.
Since September 19th.
Yes, sir.
You come back. I can do September 25th or October 2nd.
Your Honor, September the 25th will work just fine. At the 22nd, excuse me 1 second, Your Honor. Your Honor, it's September 25th for the time being. We may have a conflict with that, but if we do, we'll contact the court. I know I have a conflict on the 2nd.
Hearing no objection, probable cause conference, September 25th, 2025, 9 a.m. Bond continue.
Thank you very much.
Thank you, Your Honor.
Court calls case People versus Samuel Klosky.
And then on behalf of the people, Your Honor.
Anybody see Mr. Drukas?
Mr. Patel. Yes.
I'm sure he did.
I go fine.
Where is he? I realize, Ms. Cannon, you are trying to stand in my eyesight, so I know that you're actually here and we're waiting on somebody else. No, never mind. You don't have to say anything. I'm just saying, I get why you're there.
My apologies, Judge.
Your name, sir?
What's your name? Samuel Klosky.
Thank you.
Your Honor, we are asking that this matter be set for preliminary exam.
All discovery complete?
To my knowledge, yes.
People have their witnesses available the second.
We'll do our best, Your Honor.
Preliminary examination in person, September 2nd, 2025, 9 a.m. before Judge Freshour.
Thank you, Judge. Thanks, Your Honor. All right.
Bond continued. Court calls case People versus Eric Lightheart.
Good morning, Your Honor. Christopher Shemke appearing on behalf of my client who approaches.
Your name, sir?
Eric Lightheart.
Thank you. You're seeking an adjournment?
Yes, Your Honor. I'll have that go on.
That objection, probable cause conference will be adjourned to September 2nd, or September 4th, excuse me.
Your Honor, if possible, I was respectfully requesting consideration for the 18th of September. I fully expect the matter to find a resolution. I do not see this matter being set for an exam.
5 weeks out.
But I wouldn't be seeking any additional adjournments.
Any objection from the people? September 18th, 2025, 9 a.m. Bond continued.
Thank you, Your Honor. Thank you.
Court calls case People versus Kyle Beckerman.
Good morning, I'm pleased Honorable Court, David Burgess on behalf of Mr. Beckman. We got our discoveries complete. We're requesting exam on this matter.
Your name, sir?
Kyle Beckerman.
People have their witnesses available the second. Preliminary examination in person, September 2nd, 2025, 9 a.m. before Judge Perry. Bond will continue. Court calls the case of the People versus Latanya Marie. Oh, I'm sorry. Yeah, Latanya Marie Lee. Let's see if I get that wrong. Naya Lee. They have it. They have those.
Andrew Childers appearing on behalf of the People. Good morning, Your Honor. Sam Bernstein with on behalf of Ms. Lee. Ms. Lee, could you please state your name?
Naya Lee.
Your Honor, we're asking for an adjournment. There's some discovery that still needs to be produced, and we're working on a resolution. So a lengthier adjournment would be appreciated, Your Honor. Respectfully requested.
The 4th.
Like a 30-ish.
Pardon?
You said to the 4th, Your Honor? Could be a little
If
bit
I'm giving suggestions. Go ahead.
like the 18th, Your Honor, please.
18th. Why? This is 5 weeks out. The other one was a retail fraud. I don't even understand why we sent that out 5 weeks. And this is
Yeah, I guess that is a little bit lengthy. September 11th, Your Honor.
September 11th, 2025, 9 a.m. Bond continued.
Okay.
Court calls the case of the People versus Christopher Decker.
Good morning, Your Honor. J. Grant Miller, P58658, on behalf of Mr. Decker, who approaches. Please state your name.
Christopher Decker. All right, you're requesting a forensic exam.
Yes, Your Honor. I met with Mr. Decker. There were some concerns raised during our meeting Saturday, so we're requesting a forensic exam. I've received the paper discovery from the People. The prosecutor also has provided me the email address, and I already sent over a request while waiting to be called for the digital discovery. I think the only holdup is how long it'd take to get the forensic center to see my client.
Forensic examination evaluation is ordered. I'll set a competency here and give me 90. We'll move it up. Yes, sir. November 13th, 2025, 9 a.m.
And Your Honor, my understanding is I don't believe bond's been addressed in this, and we just asked the court to reserve that. There's a revoked bond from a case that's already been bound over to circuit court. So I don't believe any of this time is counting on this case, but we just didn't want the court to deny bond or take any further action until we get a response back.
He's got a 25,000 cash. Sure.
On this case, thank you, Your Honor.
Thank you. Bond will continue. Court does call the case of the People versus Carlton Cross.
Yes, sir.
Mr. Feaster's case.
Lauren Brown, Deputy Chief Public Defender, placeholding.
Sir, can you state your name, please?
Yes, sir. Cross and Deion Cross.
Thank you.
What did Judge Forshell Feaster, Assistant Public Defender?
Thank you for joining us.
Apologies.
What are we doing in this?
Thank you, Judge. I've been trying to work with the prosecutor to receive an offer on this case. I believe it's the first PCC. We have not yet received that offer. I will request a brief adjournment to see if there is an offer we can possibly get to resolve this.
That objection, August 28, 2025.
Thank you, Judge.
Continue. Thank you, Mr. Cross.
And sir, Judge
I'll come
Simpson.
down and talk to you, Mr. Cross.
Okay, and Judge Simpson, and I've already, on my other case, I've already been released the treatment, and I'm just waiting for Miss Sarah at correctional service to come down and talk to me.
Okay, I'm sure that'll happen. Okay, and if there isn't an order on this case, they can prepare an order and I'll sign off so that this case doesn't hold you up, okay?
All right, thank you so much, sir.
Thank you.
Have a good day.
You do the same. Court calls the case, People versus DeLorean Hall. So.
Joseph McNally, people, Your Honor.
Morning, Your Honor. Sam Bernstein with on behalf of Mr. Duhall. Mr. Duhall, could you please state your name for the court?
DeLorean Duro.
Sure, apologize. Your Honor, two things. First, I had spoken with Mr. Durrell about setting this for exam, but in reviewing the discovery after we spoke, I realized that there's some more discovery that I would need before setting it for exam, so it's not there quite yet. I still have to fill out a green sheet for Your Honor, but I'm asking for a short adjournment to do that, please.
August 28th, 2025, 9 a.m. I'll need a green sheet. Bond will continue.
Judge, I was hoping to address bond for Mr. Durrell. Your Honor, Mr. Durrell suggests that he has a number of community supports and stability in the community that would allow him to be monitored safely. He does live with his father in Southgate. His father is a business owner and he works for him. He is being groomed to take over a management position there, and he's made a lot of strides there. He also works full-time at McDonald's, 10 to 6 weekdays, Your Honor, and he has a 4-month-old baby at home. He is asking the court's consideration for bond review.
Response. I'm sorry, I did not hear any of that last part.
I believe, Your Honor, the bond has set is appropriate to the nature of the charges that I'm facing. But hopefully after this criminal history. But given the fact that this defendant is charged with armed robbery, I think the bond is appropriate as set. People for the court to make further determination.
At this point, what I'm gonna do is I'm gonna deny the motion to modify the bond in this case. Bond will continue, however, Mr. Garcia, if you'd like to file a written response so I can get more information, since I didn't get any for the people, I'll be more than happy to consider it.
We'll do that, Your Honor. Thank you.
Court calls case People versus Alexander Sanchez Garcia.
Good morning, Your Honor. Nicholas Monterez on behalf of Mr. Alexander Sanchez Garcia, present to my right. Mr. Sanchez Garcia, can you state your full name for the record?
Alexander Sanchez Garcia.
Thank you. You're requesting an adjournment.
I am, Your Honor, and I spoke with the people before stepping up to the lectern here. If the court would like more information, because the green sheet is a bit vague, then I'm happy to give it, but the people and I, we're asking for 3 to 4 weeks, Your Honor.
That objection, probable cause will be adjourned September 11th, 2025, 9 a.m.
Thank you, Your Honor.
Bound continue.
Thank you, Your Honor.
Court does call the cases of the People versus Todd Reberg.
Andrew Childress appearing on behalf of people. Carl Burdell appearing on behalf of Mr. Reberg in the case ending in 5649.
And good morning, Your Honor. Laura Yagi, Assistant Public Defender, with and on behalf of Mr. Reberg in all his other matters. Mr. Reberg, could you state your name for the court?
Todd Reberg.
Thank you.
And Your Honor, I would ask you to approach on these matters.
Come on.
Thank you.
Judge.
Good morning once again, everybody. Happy Tuesday. Welcome to the Courtroom Files Live. Well, he is muted. And he's a little bit grumpy, so I think that leads quite well into Judge Grumpy Pants down in Miami-Dade. Let's see how her morning's going.
A case from December 16th of 2024. The charge is robbery by sudden snatching. I will appoint the public defender's office for you. There's probable cause for the charge. Sir, are you currently living with the victim at this time? No.
No, I'm not living with.
Not
All
living
right.
together, but they're still.
She's not here to tell me she's not afraid, so I need to do the stay away order, okay? So, sir, no contact with the alleged victim whose initials are AB, and no contact with the victim either directly, indirectly, in person, in writing, by telephone, or through third parties. No contact with the victim through social media or other electronic means. You must stay at least 500 feet away from the victim, her home and school and place of employment at all times. Do not engage in any criminal activity. Do not use or possess illegal drugs. And do not use, purchase, possess, or carry a firearm, gun, weapon, or ammunition. You must immediately surrender any firearms, ammunition, and any concealed weapons permits to the nearest police department and file a receipt with the court. And also, third-party contact will be permitted for exchange of your child for time sharing with the victim. But if she doesn't want to agree through a third party, you have to go to family court. You understand?
Yes, ma'am.
Okay, I'll set a bond. One second, let me see one thing. What do you want me to say, 2,500? That's the bond?
Yes.
I mean, it's from December, I can,
Did you reduce it some?
yeah, I can reduce it. I'll make it $1,500. Have a good day.
Sorry, Your Honor. Who is the clerk today?
Eric.
Thank you.
Next is Keandra Berry on page 1. We have another interpreter raising their hands, okay.
Your Honor, Miss Berry was on house arrest and she was rearrested on this charges.
But this does not violate her bond.
Miss Mondana, you're leaving us? Because I see another interpreter's here.
I'm checking on my chat right now. I didn't know I had to leave.
I was told you were here today.
Oh, no, they're telling me to disconnect if my services are not being used.
Yeah, no, yeah, we're not using you right now. So we have another
Yes.
interpreter here to replace you. Thank you.
You have to go to another hearing, Maria.
Okay, thank you.
All right, Keandra Berry, good morning, ma'am. Ms. Berry, you were arrested for a case from May 22nd of 2025. The charge is burglary with an assault or battery on a person 65 or older, and criminal mischief. I will appoint the public defender's office for you. You're also out on felony bond on case F.
Judge.
This case predates?
It does.
Thank you. So there's no hold for F 25-10918. Once I have to review for probable cause. There's probable cause for everything. I don't know what she got against this 71-year-old lady. She threw a can of beans at her and then punched her 23 times. And took her cell phone also. Anyway, ma'am, you were ordered to stay away from the alleged victim, whose initials are FD. No contact with the victim, either directly, indirectly, in person, in writing, by telephone, or through third parties. No contact with the victim through social media or other electronic means, and you must stay at least 500 feet away from the victim, her home and school, and place of employment at all times. Do you understand the stay away order, ma'am?
Yes, ma'am. No longer live in that building.
That's good. Okay. So I dropped
Would
that
you
right.
consider putting her on house arrest on this case also, Judge? Looks like she's been
Very-
doing fine on house arrest.
I
You know,
don't-
Building away.
So there was a motion, let's say. There was a motion to revoke bond. That was. I don't know, there's been a lot of movement in the case, Judge. I'll
You gotta go see the division judge on this one. I'm so sorry. I gotta hold her no
There was a
bond. This is
motion a few
This
weeks
is a
ago.
violent burglary with an assault or battery. So I'm granting, as to count one, I'm granting the state's motion for pretrial detention pending final hearing, holding you at no bond. Count two, the battery on an elderly person. I'll set that at $1,000. And count three, criminal mischief. I didn't see a value for the dent to her car from the can of beans, $150.
So Judge, it was the phone, I think, is a criminal mischief.
I thought the criminal mischief, she threw a can of beans at her from the balcony and it hit her car.
She also grabbed the victim's phone, smashed it against the ground, ultimately threw it down the stairs.
Oh, okay. There's probable cause for criminal mischief then. All right. You'll see the division judge tomorrow. Have a good day.
So allegedly, there's another high-quality defendant. Food violence has kind of become a thing. I'm going to drop a link in the chat right now for a video we posted the other day where a person assaulted his mother with a spear, and it was over a dispute involving butter. This is how ridiculous we have become. So anyways, let's get back to the judge.
Rodriguez, you were arrested for battery on a person aged 65 or older. I will appoint the public defender's office for you.
So they're roommates, unless I missed it, I didn't see
And age. There's probable cause for battery. Ma'am, you are ordered to stay away from the alleged victim, Anita Zizel. No contact with the alleged victim, either directly, indirectly, in person, in writing, by telephone, or through third parties. No contact with the victim through social media or other electronic means. And you must stay at least 500 feet away from the victim, her home and school, and place of employment at all times. So I'm setting a bond. It's going to be pretrial services alternate $1,000. Also, you can return to the victim's residence one time only within 48 hours of your release from jail. You must be accompanied by a police officer. so that you can retrieve your personal clothing, health items, medication, personal and business-related paperwork, and work tools. If you go to the victim's home without the police, or if you stay there, you will be arrested. Do you understand the stay away order, ma'am?
Yes, I understand, but I didn't fight.
You're presumed not guilty. It's up to the state to prove their case against you, ma'am. Just marking up first the stay away order. Give me a second. Next is Sandra Gauss. Good morning, ma'am. Still on page 1. You were arrested for aggravated battery with a deadly weapon and domestic battery. Ma'am, can you afford to hire an attorney?
You have money to hire an attorney? No.
I will appoint the public defender's office for you. So I need a moment to review the arrest affidavit for probable cause.
It's a knife and the victim
There's
needed.
probable cause. Ma'am, you are ordered to stay away from the alleged victim, Lot Perdomo Marcia. No contact with the alleged victim, either directly, indirectly, in person, in writing, by telephone, or through third parties. No contact with the victim through social media or other electronic means. And you must stay at least 500 feet away from the victim's home and school and place of employment at all times. Do not engage in any criminal activity. Do not use or possess illegal drugs. And do not use, purchase, possess, or carry a firearm, gun, weapon, or ammunition. You must immediately surrender any firearms, ammunition, and any concealed weapons permits to the nearest police department and follow receipt with the court. You may return to the victim's residence one time only within 48 hours of your release from jail. You must be accompanied by a police officer so that you can retrieve your personal clothing, health items, medication, personal and business-related paperwork, and work tools. If you go to the victim's home without the police, or if you stay there, you will be arrested. Do you understand the stay away order, ma'am?
Yes.
All right. The victim had to get 3 stitches. Count 1 will be $6,500 for the bond for aggravated battery, and count 2 battery will be $1,000. I split the bonds. $6,500 and $1,000. Next is Larcina Moore, page 1.
Miami-Dade certainly has no shortage in violent crime. That is for sure. It seems like with all of the courts that we watch, they're way up there on it. I was going to go back to Judge Simpson, but just that fast, he is back in silent mode. So let's go to Texas and say good morning to Judge West.
Is this our first president? Yep. It's mandatory, right? Not mandatory.
If you want to go to trial and not accept a plea agreement, then listen to your attorney and do what he's telling you to do.
Okay, so basically it's completely off the table right now, the plea?
Yeah.
Right there, and there.
What's all this?
Defamation, man. They've been gaslighting me for 5 weeks straight. Been doing my best to get to the population going on and try to stay out of trouble. They all look on the microphone.
All right, this is, stop talking. This is clause numbers 24 DCCR 1500, 24 DCCR 1614, 1615, 25 DCCR 0436, and you're Traylon Hill.
Yes, ma'am.
And Mr. Hill's charged, let me go through this, in cause number, the first one, 1500, with obstruction or retaliation. Do not do that again.
My apologies.
Who's in here for him?
My grandmother.
All right, ma'am, can you move over to that back corner so that he cannot see you and be distracted? Thank you for being here. Mr. Hill, you just don't know how to behave, do you?
I apologize.
Saying you're sorry doesn't matter. This is nonsense. Since we were here last time, I don't even know how many more pages of the nonsense that you've been doing in our jail.
It's gaslighting. It's solicitation.
Okay.
And I've been trying my best to stay out the way. I've been getting bullied over the microphone. I have inmates, they're encouraging the inmates to harass me, calling me punks, alpha, profit, you know, plenty of things. Gangster player, mad.
Yeah.
Mortar. Man, I'm just trying my best to stay out the way.
Okay.
I got a job, I got a home, an actual home. I don't stay in apartments or anything like that. My mama actually owns rent houses. And you know what I'm saying? I'm actually trying to take care of the family business. And my dad's 76 years old.
Yeah.
I'm trying my best to stay out the way.
Well, it doesn't look like you are.
Yeah, it's tough in that facility. It's a war zone.
So one of the time you're running back and forth, playing like a little kid in the day room. Who made you do that?
I'm a boxer. I work out.
Are you allowed to do that in the jail?
In the rec room, yes, ma'am.
Okay, so are you allowed to do it in the other room?
I have a one-man cell in the facility.
Are you allowed to do that?
Yes, ma'am.
You are?
I'm not running freely throughout the facility or anything like that, but I do work out a lot every day.
So who made you dash the floor with water?
Everyone in that facility has a water
Who
bottle.
made you dash the floor with water?
I'm not the only one. That was
Listen
me.
to my question.
No one did.
No, but you did it on your own,
Yeah, but
right?
it wasn't
Nobody's
organic.
stop talking when I'm talking. I'm gonna ask you some yes or no questions.
Okay.
So nobody's making you do those things, right? Nobody bullied you into dashing water, right? Yes or no?
Yes, ma'am.
Okay, hold on a second. What about why do you continue to make comments to the female officers out there? Why do you think that's okay after you've been told not to do that?
Sitting in the cell all day long, man. When I see them women, I get hurt. I'm a little boy. I admit that.
'Cause you're a lover boy?
Yes, ma'am.
So you understand that part of all of this trouble and you not being able to get your cases worked out is because you can't follow that rule.
Yeah, I hate that.
Did somebody bully you into being that way to those officers?
In a manner, you know what I'm saying? When
Oh,
I'm
yeah?
dealing with these stressful inmates, you know what I'm saying? I love to be around mom.
Okay.
My mama boy.
Judge, based on his Sunday night activity, I'm pretty sure there'll be a new case coming.
Yeah.
I've got to call into the investigator for the sheriff's department to find out
Okay.
when they'll bring that over. But I would ask that we go ahead and set these in for trial.
And we've already talked before about the fact that everything that's happening, a jury is gonna know about all that. You understand that? Okay, and do you think that's gonna help you or hurt you when a jury hears how you're behaving in the jail?
When it comes down to video footage and how I explain it, I think my efforts will be pretty good.
You think so?
Yes, ma'am.
You think
She muted herself. I wonder if she's swearing at him. That would be funny if she was. Oh, that was a shame. That was just getting good. Well, I'll keep an eye. Let's, she probably just bumped it because she does that a lot. She has a problem with her mute button. Let's stay in the building. We'll go over to Judge Stevens.
Okay. In this case, for the state jail felony of unauthorized use of a motor vehicle in 25 CR 780. If convicted of such a thing, it carries with it up to 2 years in the state jail. And here, put your down in there. Feel like I'm in school now.
Right.
Langston's mother would get you on that, being the educator she is. And anyway, it carries with it up to 2 years in the state jail, which is serious, and it's a state jail. It's a felony offense. You've never been convicted of a felony before. You don't want it. You know how long that straddles your back the rest of your life. So it needs to get fixed, and he can do it. He can help you. How much time do you need? 4 weeks?
4 weeks.
Okay.
Over.
Get a resetting there.
Thank you, Judge.
Get a resetting break here, sir. Thank you.
I'll meet you outside.
Paris
He's here.
Ross.
Mr. Ross. He is here, Judge.
Got it.
Yeah.
Mr. Papian, you got to come here outside.
Let's see. What are you wearing? Let me ask you this. Would you wear that to church? Would you wear it to church? Maybe you would. But this is, look at everybody. Everybody's got it. All the men have ties and the ladies are dressed. This is a place of honor. We're talking about the Constitution.
Yes, sir.
It has its reverence and its humility and its integrity. You don't have to wear a tie or anything, but just not a bright T-shirt that's got some kind of a message on it. I can't even read that. What's that saying? Does that say something up there?
Godspeed.
Godspeed. Uh-huh. What's down below? Let me see. It's a car, vehicle. What is it? Oh, it's getting gas. It's a gas guzzler, I guess. It's a gas guzzler. Looks like a Datsun or a foreign car, sports car. All right. Just dress decently. Yeah. All right. You were charged with some serious offenses here. In 25 CR 381, you were charged with the second-degree felony of fraudulent possession or use of credit or debit cards. If convicted, this carries with it up to 20 years in prison. 25 CR 382 is not much less of a serious felony either. It alleges that you committed the third-degree felony of forgery. Looks like it must have been at the same in the same episode.
Yes, sir.
They carved out two crimes. Third-degree felony carries with it up to 10 years in prison if convicted. So you're looking at up to 30 years in prison if found guilty on these cases. This is an admission.
Yes, sir. I just want a little bit more announcement.
4 weeks good on this one too.
Be good.
I don't see a criminal history here, right? You don't have a criminal history? Do you have felony? You have a felony in this county?
No, sir.
Okay.
I'm not from Texas, Austin.
I see you're at Atlanta, Georgia.
Yes, sir.
Well, that's that you need to navigate through that. Whatever your convictions are in Texas, you lose opportunities for probation if you've been convicted of a felony before, depending upon the circumstances. He's a smart guy. He knows how to navigate through all of this. 4 weeks.
That'll work.
Okay, please get a reset. Thank you.
Thank you, Judge.
Yes, sir.
We'll go outside. Yes, and we will.
I don't see Mr. Grove. James Paget, are you ready? Are you working on something?
No, I'm not. I have a key Ballard. I actually have 2 cases on the dockets.
Kia Ballard or Ballard.
We'll see. Thank you.
I don't do it. Well, sometimes we'll see.
Kia Ballard.
It should be in the hallway. Okay.
Oh. That's let's see, who's the lawyer on? I don't see
Two on either judge. I don't have to think much of this time yet. It's
really.
I want to say
Nobody wants to prosecute this, I guess.
I'll have my motion filed.
That's you got it, buddy. You don't need to write anything. Just tell me.
I can make an oral motion.
Yeah, it's good enough for government work.
Well, I know there's something. Well, never mind. Stop right there.
Okay. Kia Ballard or Ballard.
Look at you, stepping. Judge, look,
What
it's
happens?
very honorable. He's just stepping up.
It looks like he's the American flag too, by the way. Yeah, you see,
Right there.
he's got the flag on you.
He'll keep
He's waving the flag.
How are you?
Good
Good seeing you.
evening.
Kia Ballard,
Hiya, Ballard.
Kia Ballard,
Hiya.
Kaya Ballard.
Yes.
Miss Mel. That's what I do. That way I don't mess it up.
The name is a bit tricky.
You are indicted here in 23-41367 with the state jail felony of abandoning or endangering a child, which if convicted carries with it up to 2 years in the state jail, and it's a felony, which you don't want.
Yes, sir.
That a felony conviction you have to carry with you the rest of your life. So that closes a lot of doors of opportunities and privileges that you don't want to close.
Yes, sir.
Mr. Pageant, very good lawyer, and he knows how to help people. What are we going to do today?
Here's where our issue comes in, Your Honor. It looks to me like this is an extremely old case. So, this is my first appearance.
You won't believe this, but I got some in the 20s.
I do understand that.
20s. So
she hired me just a short time ago. I filed the proper documentation.
2.5 years ago.
Right, but as soon as she hired me, I filed all the documentation. I filed on 7/12, my letter of rep. I'm in the process now of reviewing the body camera footage and the dash camera footage.
What is your address?
Mine?
Yes.
2680 North Street, Beaumont, Texas.
See, generally, when we have an issue like this, the address, they've moved from the address that was given at the beginning, but
You're not
she
in
didn't.
trouble. He's just making an observation.
She didn't. I mean, this is the same address. I wonder this was indicted in January of 23.
Your Honor, I can only speak from like 7/12.
When did you receive a copy of this? Do you remember of the indictment? When did you find out you were indicted? Recently?
When I went to jail.
When was that?
March. I about to say March, I believe.
This year?
Mm-hmm.
Wonder why it took.
I didn't even know when I got.
I mean, that's your
address.
They normal, and it was indicted in 23.
Because I remember when I went to jail, I got out on accusation, and then I never heard nothing about them picking it back up. So I just assumed it.
You mean, okay, that was originally, that was in 23?
2022.
2022.
Yeah, the end of September 2022.
September 22. I don't know what happened on that. That's weird.
So I'm working diligently
from the beginning. You're starting.
Well, it won't take me. If you would give us 30 days, I'll be ready. I have
5 weeks
from the state
5
already.
weeks.
Whatever pleases.
All right. You got 5 weeks.
We're moving at a good pace on the case. And I have an offer.
Have you been convicted of anything before, man?
She has not.
No.
Nothing.
Now, she does have a failure ID out of the same transaction, which I'm going to step down to the involved shortly.
Well, again, that's fixable.
Understand.
We offer deferred, Your Honor, so we'll see what they have to say, and they may work it out. So.
Good, because you don't want a conviction, felony conviction.
I really don't.
Yeah, there's a way.
Get in the medical field.
Oh, good for you.
Yes.
Good for you. My daughter is
Yes.
manages hospitals, and
that's what I want.
you
Start
help
out as
people.
an RN.
You help people. Yeah. Are you an RN?
I want to start out as one. I don't want to.
Where are you in your medical field?
I'm not
nursing.
yet.
Oh, you hadn't started.
Get there,
Well,
but
one step at a
finish
time,
this
and you get
first.
there.
Yes.
In the right direction. Well, you know it. Okay, good for you. Okay, please get a resetting from that lady.
Thank you, Your Honor.
Thank you.
Quinteller Matthews.
My understanding, I received a call from the bonding company this morning. I have not verified this myself because I haven't got a response from her. The bonding company tells me that she was contacted. They were contacted by family this morning and she's in the hospital. The bonding company, the gentleman I have a good relationship with, we're trying to get. I'll call him. Okay.
All right. Thank you
The
so much.
bonding company, we're trying to get documentation now that she is currently hospitalized. I cannot vouch for that because I haven't been.
I understand.
So it was an early phone call I got from Bell America.
In 25 CR 271, Quinteller Lachey Matthews, the defendant was indicted on February 26th of this year for the state jail felony of theft. And looks like this occurred at Marshall's here in Beaumont.
That's correct, Your Honor.
Nice store. And then the problem is that she has, according to this, 7 prior convictions.
I would agree with that.
7 felony convictions of theft. All out of district courts of Jefferson, Hardin, Fort Bend County. Okay, so paragraphs 1 and 2 constitute, she's in a situation where if she steals a pack of gum, it's a felony.
I understand.
So that's a state jail felony. There is no answer to quiet teller Lachey Matthews in the courtroom. I'm asking the bailiff to call into the hall for quiet teller Matthews, please.
Quiet teller, quiet teller,
Interesting first name, family name.
I would have to agree with that. I haven't got into it that deep with her.
There's no response, Your Honor.
There's no response to the name called here into the courtroom and no response to the name into the hall. Defendant has failed to appear, maybe because of a good reason, but the court's going to enter findings that the defendant has failed to appear. And Mr. Patchen, on behalf of the defendant, has heard or has information that she may be medically unable to be here. But what we're going to do is order a until such time we can get certainty, we're going to make a finding she has failed to appear. A warrant shall be issued for her arrest. What's her bond?
$7,000.
And bond is doubled to $14,000, and a GPS device must be acquired unless the court receives information that she was unable to be here for a good cause. All right, that's that one. Is that it? Is that
Two.
Well, he has 2 more?
No, he's done. Sorry.
Oh, okay.
What's your name, Jim?
Thank you. Looks like Kedrian Corbin, John West, Betty Handy, John West, Jimmy Vin Wynn, John West, and Ross Mac Owens have been reset as they have been reset to another date, or they have hired attorneys and we have received information of that. So anything else? We've got 2 other cases. Yeah.
They took the videos. You talked to Arson.
Okay.
So I'll keep an eye on Judge Stevens' court, but let's go back up to Judge Simpson. But before I hit the go button, the guy in the bottom right there, I think he just can't take it anymore. He looks like he's had enough already.
Sorry.
My name is Tossam Samara. Your Honor, we are simply asking the court to set this for preliminary examination. I believe I have all of the discovery, and then I can address the community corrections issue.
Why don't we address the community corrections violation now?
Yes, Your Honor. There is a slight language barrier with my client. He does have a green card, but he's from the country of Eritrea, I believe it is. He tells me that he didn't receive any paperwork when he was released from custody, so he didn't know exactly what to do. When I got the notice of the violation from community corrections, I advised him to go over there. He said he did go over there twice yesterday, asking to be enrolled in the intake process. He said that they told him they didn't have any paperwork for him to do that. So he's happy to do that right now.
That's not true.
I don't think there'll be any problems.
It's not true. There's paperwork over there. I can see the paperwork over there. And if they didn't have paperwork, they wouldn't have sent the bond violation. He's not telling you the truth.
I did. Well, I apologize, Your Honor, on his behalf. He tells me there shouldn't be any issues if the court wouldn't mind passing hit for him to do.
When did he say he went over there? Because I'll call right now.
Yes, sir. yesterday afternoon.
Yeah.
They wouldn't have. It's not true.
I
can tell, because I've got the bond violation here from me.
Okay. This is his first experience on this level with the legal system. So I would ask.
Probable cause conference will be adjourned August 28th, 2025, 9 a.m. At this time, the defendant's bond is revoked. Defendant's remanded. Are they ready? Court does call the case, People versus Carlos Sell.
We're hearing on Mr. Self, who's approaching the podium as we speak. Carlos, once you get up here, please introduce yourself to his honor.
Carlos Sell.
Thank you, Your Honor. I had previously represented Mr. Self in the matter ending in 5140. Late yesterday, I was just appointed to his other matter, 5186. We are asking that both matters be adjourned in order for me to review discovery and work on a global resolution with the people.
Probable cause conference in these cases will be adjourned August 28th, 2025, 9 a.m. Bond continued.
Thank you, Judge.
Okay, I'm happy to introduce a news segment here on TCF, Geography with Dan. So the previous defendant was from Eritrea, and I had no idea where that was, so I looked it up. It is in Africa. It is across from the Red Sea, from Saudi Arabia and Yemen. Borders Sudan to the west, Ethiopia to the south, and Djibouti is on the southeast side. Eritrea, along the Red Sea in Africa. Who would have knew? But now we know. So this has been Geography with Dan.
Into cocaine use during July?
I don't believe that would be related, Judge, to that particular issue. But we have reached out to Sarah Stewart in the jail about getting into Dawn Farm in-jail treatment program. Mr. Self is a business owner. He owns a barbershop. He's eager to get back to work. He has 3 employees who rely on him for their livelihood, in addition to his own livelihood at the shop. The shop is currently closed and idled while he is in custody. So we are asking that he be released to be able to return to being a productive member of community and a job provider for the local community. And so we are asking for a PR bond on these matters.
I don't need a response from the people. His bond will continue as previous, as I've said it. In this case, motion for bond reduction is denied.
Understood. Thank you, Judge.
Court does call the case of People versus Vincent Lambert.
Morning, Your Honor. Public Defender, let me sub on behalf of Mr. Lambert.
Mr. Lambert, can you state your name, please?
Vincent Lambert.
Thank you, sir. What are we doing?
I'm requesting an adjournment. Your Honor, we are missing some video. I did re-request it yesterday, and as of this morning, Mr. Childers did advise me that it should be released, so we just have to extract it and watch it.
Give you my next available date, August 28th, 2025, 9 a.m.
Thank you, Your Honor.
What was your name,
Thank
ma'am,
you.
so I can call you and ask you a question?
He's talking to you.
It's Miss Saab. Like the car, Saab.
Miss Saab, thank you very much.
Not Audi. Trying to make that clear. Court calls the case, People versus William Bastable.
Joseph, people, Your Honor.
Mr. Denua?
Hi, be next door.
Really? Didn't do me any good.
Hello. I've been. How are you?
Oh, do you know what you're doing on your case today? Did you adjourn or you said?
What's he saying? He might adjourn on video.
Video, okay.
Sorry.
Very good.
Sorry, Your Honor. Assistant Public Defender Ben Denowith on behalf of Mr. Bastable.
Your Honor, the defense is asking to adjourn a week. We've not received the video discovery. My emails of Friday and Monday were not returned. We cannot conduct the preliminary exam without the video that is referenced in the police report. So we'd ask to adjourn for a week. I do have the form in my bag.
Well, I'll need the form.
Okay.
Without objection, probable cause conference, August 28th, 2025. 9 a.m. Bond will continue. Court does call the case People versus Tanya Hall.
Good morning, Our Object going back from this hall. Tanya Stickney.
Tanya Hall.
Judge, I've just been speaking with the prosecutor in this matter. I believe we're going to work out an agreement where she's going to be allowed to plead to a misdemeanor. My understanding, we don't have a plea form today, so we're asking for a very short adjournment so we can do that.
Has she been counsel approached?
All right, well, he mutes. Let's go back to Miami-Dade, see how Glazer's holding up.
Next is Terrence Williams.
Judge, what was count three?
I don't remember what I wrote. $500.
Thank you.
500, $1, and 500. Good morning, Mr. Williams. You were arrested for 2 cases. One of them is organized fraud, $50,000 or more, grand theft, 3 counts, a second-degree felony, 3 counts, another count of unlawfully subleasing vehicles, 3 counts of obtaining a vehicle by trick, and 3 counts of obtaining property or credit by false statement. And the other case is failing to register as required by law. I will appoint the public defender's office for you. So he failed to register 7 vehicles, which he was required to. So in F-25-17929, he's charged with 7 counts. I don't know what you want me to set these at, stay at 1,000 each. I'll do 1 at 2,500 and 2 through 7 at 1,000 each. And the other case, let's see what's going on.
It's,
From June, started in June.
it's a scheme we've been seeing lately where somebody buys a whole bunch of cars in a short amount of time, lying about their
credit.
finances, and before, I guess it hits their credit score, so they qualify for all these vehicles.
He's buying Mercedes, BMWs, a Honda. All right, so count 1, organized scheme to defraud is $15,000. Count 2, there's probable cause for 3 counts of grand theft, 7,500 count 2, 7,500 count 3, and $7,500 count 4. Count 5, unlawfully subleasing a vehicle. I'll find probable cause for that. That's $2,500. Count 6, 7, and 8, obtaining a vehicle by trick. I don't know what you want, 2,500 each count, or
Fine.
6, 7, and 8 are $2,500 each count. Let's see. Then count 9 is obtaining 3 counts of obtaining credit with false statement. That's $500 for counts 9, 10, and 11. Have a good day, sir. Next we have is Darrell Jamie, page 9.
Should qualify for pretrial.
Good morning, sir. You were arrested for possession of cocaine and possession of drug
One
paraphernalia.
moment, Judge, one moment, Judge.
Oh, that's not him. What happened to Darrell, Jamie?
Jamie, come on, Jamie, come on.
Spanish interpreter, please.
Good morning, sir. You were arrested for possession of cocaine and possession of drug paraphernalia.
Posesión de cocaína y posesión de parafernalia para uso de drogas.
I will appoint the public defender's office for you.
Yo le asigno al abogado de la defensa pública.
How long have you lived in Miami, sir?
¿Cuánto tiempo lleva viviendo en Miami, señor?
25 25 years.
25 years.
I'd ask for-
Okay. Do you have a place to stay?
¿Usted tiene un lugar a donde quedarse?
All right, pretrial services alternate bond count one is count one is $2,500, count two is $500.
Ok, un programa y la fianza alterna, $2,500. Cargo 1, cargo 2, $500. Gracias.
Thank you. Next, you have Pedro Centeno. Good morning, sir. Do you you speak English? Yes.
Yes, yes.
You are arrested for aggravated battery and assault. I will appoint the public defender's office for you. You're out on felony bond. There's a hold for case F257060. So the victim says he was just assaulted by an unknown male. It was Mr. Centeno. I don't know, is it an ag battery, just a battery? The victim's bleeding, but it looks like you pushed him.
This form's really confusing. I guess a battery.
Yeah, maybe, yeah, a battery and an
I think
assault.
Right, they said that the reason it looks like the officer charged it as aggravated is because of the possible exposure, I think, but I'm not sure if that's appropriate.
Sir, you are ordered to stay away from the alleged victim, Elgin Worthy. No contact with the victim, either directly, indirectly, in person, in writing, by telephone, or through third parties, and no contact with the victim through social media or other electronic means. You must stay at least 500 feet away from the victim's home, school, and place of employment at all times, and stay away from the plaza at 501 West Palm Drive in Florida City, Florida. Do you understand the stay away order, sir?
Yes, ma'am.
Thank you.
I don't see any aggravated battery.
I think it's a battery. I understand the victim was bleeding, but it didn't state he was, how it give great detail of a weapon being used. So count one is probable cause for battery, $1,000 bonds. Count two, probable cause for assault, $250, and you'll see your judge tomorrow for your hold. Have a good day.
You said 1,000 for count one?
1,000 count one, 250 count two.
All right, let's head back to Texas and check back in with Judge Stevens.
Which carries with it up to 20 years in prison. Very serious. Your attorney, Mr. Grove, is not here. And what's going to happen is
And he's muted. They got a thing with the mute button in Jefferson County. Drives me nuts. All right, we'll stay in the building. Let's go over to Judge West.
You said turn around? No, I don't want you to turn around.
He said, how are you doing?
Oh, how you doing?
Good morning, you're Kevin Ross?
Yes, ma'am.
And so Mr. Ross has two motion to revoke probations, cause number 24, DCCR 1198, on probation for the offense of a deadly weapon in a penal institution, and in 24 1199, evading arrest or detention with the use of a vehicle. Mr. Burbank has filed motions asking that I set bonds in these cases. Give me just a second to get this pulled up.
Judge, if I may, just
Yeah, go ahead.
inform the court, we have discussed this at length, Mr. Burbank and myself. I have made several requests to DPS via my investigators to bring the new evading. Typically, we could proceed on a motion with just a probable cause affidavit. The alleged egregiousness of this evading lends to an absolute need for the video, which is what Mr. Burbank wants. Considering DPS has not brought that, I feel like in fairness, I cannot oppose a bond for this defendant because I think that the video itself will be dispositive of either he was driving or his brother was driving, is my understanding. I've made requests of the trooper and they just have not brought it in. It's a June 13th date.
And if I may add, Judge, I will represent to the court, I do have an affidavit from another individual, but I need the video, because we could really shortchange it, get right to the point.
Who's the trooper?
And I'll try to reach out again.
I'll reach out this afternoon after docket. So I'll figure, it looks like there are other allegations.
I'm sorry, Judge.
And so,
Garcia, Jordan Garcia.
I'm sorry.
Jordan Garcia, I seen Judge on something else up on my mind.
In addition, Your Honor, Magistrate Court.
Yeah.
In my motion, I also add, if you were to consider a bond, some other requirements that I believe would be necessary.
And I've spoken with his probation officer and whoever, she understands the situation.
So we've got allegations of the evading with a vehicle and just an evading on June 13th. And then possession of marijuana from June 13th as well. And then drug patch, tested positive for cocaine. Out past curfew, June 13th at 1:39 a.m.
I have the PC on that today, Judge, if that would help.
I think I might have it right here. Let me take a look at that as well. Here's what I'm going to do today. I'm going to hold the motion to set a bond. We're going to, I'll contact DPS as soon as docket is done to see what it takes to get that video. If we can get it quickly, then everybody can look at that and see where we are. If for some reason we cannot, then I will reevaluate and set bonds at some amount based on the nature of the allegations and all of that. So, but
Mr. Bates reach out as well, Judge.
Okay.
This morning while you're on the bench. So
Okay.
they can get-
if you'll let them,
When they know the court is.
if Detective Bates will let them know that he's gonna call them or I'm gonna call them, so maybe they can get that very quickly, and we'll go from there. All right, go back with the bailiff. I'll, at the most, we'll reset it for a couple of weeks, but if we get that, then we'll figure it out as soon as we have an answer today. I'll get with both of you. Okay, go back with the bailiff. And then you have Carrington Scott.
I can announce if you don't want to.
No, we need to get them out, please. Mm-hmm. Oh, okay. Have we seen or heard from him? This is Mr. Smith's case on Carrington Scott. Good morning. Are you Carrington Scott? And this is 25 DCCR 0538. Mr. Scott's charged with robbery. Mr. Burbank?
Your Honor, I have reached out to Mr. Smith. I understand what's going on. There is a video that is missing, and he was attempting to try to get it. The court could do two things. It would probably be dispositive of this case if we receive, it's a convenience store robbery, and some of the cameras were missing.
Okay.
The tape. If you want to reset it for a couple of weeks, I don't know when Mr. Smith will be back.
I'm sure Ms. Malfino or Mr. Nichols can
We
step
can
in.
handle it, Judge, and I just want to let the court know, Mr. Smith has documented that he did reach out to the detective on August 12th. I'll be happy to follow up.
Okay, thank you, Ms. Malfino.
It's a
So we'll
missing
just,
Convenience store video, some of it was already erased, so I think, I agree it would be dispositive.
okay.
Be dispositive of it. I mean, he's rejected the 15 years from Mr. Rojas, Judge.
All right, we'll just do maybe about 3 weeks. That'll give Mr. Smith, when he gets back, or Ms. Malfino, sounds like she'll step in and try to take care of getting whatever information they can, so that we'll, if they have it, you can see it. If they don't have it, then we'll figure it out from there as well. All right, thank you, Ms. Malfino.
I think that's all I have.
It is. Thank you, Mr. Burbank.
We're going to go visit with Judge Simpson in just a moment, but before we do, I wanted to direct your attention to what you see on the screen, and that is the upcoming episode of Sidebar tonight, 8 p.m. Eastern, 5 p.m. Pacific. We have a very interesting topic. We are going to discuss how artificial intelligence is being used all of a sudden to write police reports, and it is not so much being used all the time as an assistant. It's often completely taking the place of humans. So we're going to discuss that, hash it out, see what's good, what's bad, what's broken, probably talk a lot about what's bad and broken. But again, 8 p.m. Eastern, 5 p.m. Pacific. I think it's going to be a great topic, and if you haven't checked out Sidebar, join us. Because the people that you see on the screen right there are obviously me, but also Bailey and Ashley and Michael from our audience here in the morning show. This whole show was their idea, and we're having a lot of fun. It's a blast, so be sure to check us out. All right, let's go to Judge Simpson and see where he's at.
Court calls the case of the People versus Ronald Lucky.
Joseph and Gilman, people, Your Honor.
Judge, in this matter, we'd like to set this matter for a preliminary exam.
Your name, sir?
I'm Ronald James Lucky.
Discovery is complete, Mr. Kidwell.
Yes, Your Honor.
People have their witnesses available to second. Preliminary examination, September 2nd, 2025, 9 a.m. That is before Judge Perry.
Judge, may I address an issue? Mr. Lucky was staying where the incident, the allegations against him. He was renting a space at 1074 East Forest. He's not allowed to go there. All his worldly possessions are there. He has tried numerous civil standbys. He said he even got a court order that he could get his belongings. Can you be of any assistance, him getting his property from there?
I'm not moving anything, if that's what you're asking.
Pardon me? No, I'm not asking you to help move them. No, not, you know, that.
Judge Otis.
Well,
Ordered it in
who
writing.
ordered it?
The one that let me out on bond, I believe Judge Otis, they wrote it down on a post, you know.
It's Odetella.
I'm
It's a
sorry.
magistrate.
I'm sorry. I didn't have my
I'm
glasses.
gonna tell him you called him Otis, though.
Sorry.
Funny.
Right.
Right. Like the elevator. You have an order that allows civil standby.
He said he was issuing a written order for me to have access to my property. That's what he said on Zoom when I got bonded out.
Has he issued it?
He said he did. I was in custody. I didn't have a pen, a paper, a case number. I have nothing.
Would that be reflective in the file, Your Honor?
I don't see an order. Mr. Killowall, if you prepare an order permitting civil standby to that address to retrieve his property, I'll sign off on it. I don't know.
Okay.
Sure.
All right.
Nothing.
Huh?
Sheriff's done nothing. I've been there more than 10 times with the owner. There's witnesses.
We'll have a court order.
Thank you.
If he gets a court order, I'll sign off, sir. It'll have to be done today, otherwise I'm out for about a week, so.
I'll have it done this afternoon.
All right.
Thank you.
All right, thank you, Your Honor. Do we set the, oh yeah, we did say.
Also, the court
Wait a minute,
keeps me
hold on.
on my, that address.
Okay, we're gonna take care of it.
September 2nd.
Yeah. September 2nd.
Court call stays. People versus Nathan Gabachi. Tell Otis he needs to do an order.
Andrew Childers, Green on behalf of the people. Good morning, Your Honor. Alex Warren, Green on behalf of Mr. Gabachi. Could you please state your name, sir?
Nathan Gabachi.
Thank you.
Your Honor, at this time, we are asking the court to set the matter for preliminary examination.
Discovery is complete.
I believe so, Your Honor.
People have their witnesses available to second.
That's fine, Your Honor.
Preliminary examination in person, September 2nd, 2025, 9 a.m. before Judge Freshour. Bonds will continue.
Thank you, Your Honor.
Court calls case People versus Ashley Nader.
People, Your Honor. That's Mr.
Yeah.
Morning, Your Honor. Rob J. Kill on behalf of. Judge, in this matter, we're asking.
Your name, ma'am.
Ashley Nader.
Thank you.
Nader, I'm sorry, Judge.
No, it's okay.
Judge. Sure.
That was to you or me?
I was just.
You were answering for me, Killowall?
Judge, I'm not sure where I am this morning.
Okay. All right. Well, that leads to confidence for your clients. Come on.
Every day has a theme here at TCF. The theme today is muting. So let's talk about somebody who should never be muted, our friend Michael Groff. If you are not subscribed to his channel, you should be. You are hereby requested and required to go to his channel right now. Barbara, would you be so kind as to drop a link to Michael's channel in the chat for me? Michael is great. He is a member of the Sidebar panel, again, tonight at 8 p.m. Eastern, 5 p.m. Pacific. But as well, he does his own content. He does weather content. It is incredible. Even if you don't care about the weather, you should subscribe to Michael and watch his videos just for the voice. He has the voice of an angel, a masculine angel, but an angel nonetheless. It is soothing. It is wonderful. And you should subscribe. Again, Michael Groff, and Barbara, please do me a favor and put a link to his channel in the chat for me. Let's, let's go to Grumpy Pants. Let's go there.
Cargo 1, libertad bajo palabra, cargo 2.
Okay, thank you.
Gracias.
Next, we have Evans excess, page 12. Good morning, sir. You were arrested for strong arm robbery. It's from August 15th. I will appoint the public defender's office for you. So he's stealing a hair dye bottle from the victim. And then I guess the victim followed him, grabbed his arm to get the hair dye bottle back, and then he pushed the victim. So that's technically a strong arm robbery. He also swung the bag that had the glass bottle in it towards the victim. He struck the victim on the right side of the face with the bottle and then fled the scene. It's actually also it's a strong arm robbery with an aggravated battery, which is a first-degree felony. I don't know how the state wants to proceed, though. Are you okay with just a strong arm?
As is for now.
It should be an F1, though. Anyway, sir, you are ordered to stay away from the alleged victim whose initials are JG. No contact with the victim, either directly, indirectly, in person, in writing, by telephone, or through third parties, and stay at least 500 feet away from the victim's home, school, and place of employment at all times. You're also ordered to stay away from the Rendezvous Salon at 13741 Northwest 7th Avenue in North Miami, Florida. You're not allowed to go to that hair salon, and you must stay away from there. Do you understand?
You understand? Slow. I'm speaking Spanish.
Spanish is better?
Maybe Creole?
Creole or Spanish?
Creole is Spanish.
Which one?
Creole.
Creole, please.
We'll have to pass it for Creole interpreter. Just have a seat, please. Next, we have Evan, I'm sorry, that was that case. Next is Dorvis Lorenzo Lombardia. Bond out?
Yes.
Thank you. Wyatt Zipper.
Yes,
Good
ma'am.
morning, Mr. Zipper.
Good morning.
1 second. You were arrested for You were arrested for fraudulent use of personal identification, organized scheme to defraud, fraudulent use of a credit card, and theft of credit cards. And also petty theft. I will appoint the public defender's office for you. Let me review for probable cause. So the victim reported his car was burglarized, and they stole his wallet with multiple credit cards, a driver's license, and some cash. Then an unknown subject tries to withdraw money from the victim 2's account in Miami Shores, and then he tried to also withdraw from another account. And so the banks were sent subpoenas. So this is from May 24th. So they were able to find that Mr. Wyatt Zipper is involved in this. So one suspect withdrew $100 from victim 2's account. on May 30th. Oh, and I believe that was Mr. Zipper who did that. And Mr. Ledesma withdrew money from the other victim's account. He said he never broke into the victim's vehicle, but an unknown person gave him the victim's Bank of America debit card and driver's license, and he was instructed to take money out of the victim's bank account with the agreement to obtain a portion. And he got $50. He also identified himself in that bank video. I don't know if it's charged. Yeah, it's probable cause for count 1, count 2, count 3, count 4. Should be unlawful possession of personal identification. He said he had his victim's driver's license too. What do you want? State a bond?
Or
Free trial?
a program. Looks like he's a veteran.
Yes, I'm a veteran.
I would ask for pretrial judge.
Pretrial services alternate bond. Count 1 is $2,500. Count 2 organized scheme to defraud is $1,000.
I'm sorry, Judge, if we could do TAP, he's currently home.
Okay. TAP alternate bond, $2,500, count 1, $1,000, count 2, count 3, the fraudulent use of a credit card, $2,500, count 4, theft of a credit card, $500, count 5, petty theft, $150. So you have to come to court for your arraignment on September 18th at 9 a.m., courtroom 47 before Judge Stuzen. Have a nice day. Next case is Lewis Mora. We're waiting on the Creole interpreter. Let me know if you see her. Is Creole interpreter here yet? Did you call over? Did somebody call? Because they go to lunch. And then we won't get her till after 1:30. Lewis Mora, page 13. Good morning.
Messaging the office right now.
Thank you. So you were arrested for attempted threats or extortion, false imprisonment, operating a business without local business tax receipts. And it says doing business on property abutting the water. I guess in a restricted area. So he's doing a jet ski rental. Anyway, I will appoint the public defender's office for you. Let me review for probable cause. So there are people left abandoned by a jet ski rental company at Pace Picnic Park? Pace Park.
Island.
Is that the one in the middle of Venetian Island? So the victim said they rented jet skis from the defendant for $290 for an hour. We're only able to use it for 30 minutes. And they gave a description of the jet ski. And then they found the jet ski matching that description on the Watson boat ramp. The victims were able to positively identify the defendants as the individuals who picked them up from Venetian Causeway by the rocks. They transported victims to Pace Picnic Island, at which point they turned over the jet ski. Then the victim said the defendants never had or showed the yellow plaque required by jet ski rentals conducting livery. And then after 30 minutes of using one of the jet skis, let's see, it overturned. And so the defendants were transported to the victim. They transported the victims to the islands. Once at the island, they demanded $1,000 for the alleged damages to the jet ski. They told them they didn't have $1,000 and refused to bring them back. Okay, that's what's going on. Jet skis shouldn't turn over like that. I used to have jet skis in my younger days. Anyway, you are ordered to stay away from Omo, Barry, and Diallo, Osmain, the alleged victims. No contact with the victims, either directly, indirectly. in person, in writing, by telephone, or through third parties, and you must stay at least 500 feet away from the victims, their home, school, and place of employment at all times. All right, you understand that? Stay with them. All right, he's trying to make a buck doing a jet ski rental without the proper licensing.
Right. There's prior arrest though, it looks like regarding boats.
I don't know if it's threats or
I don't think it's
extortion.
threats and extortion. I don't
We
think it's.
won't take you up, we won't let you go off the island unless you pay for the damage.
The little tiny island. You
I
could, you,
don't even know if
think
they can
it's false
swim.
imprisonment.
is he eligible for pretrial? All right. No?
Mr. Morrow?
Yeah.
The order, man, Judge.
I think the correct charge of, yeah, I think it is correctly charged. Yeah, I'll give him a break. Go get your proper licensing or go work for a company that has it. All right, pretrial services alternate bond. Count 1 is 2,500 for threats or attempted threats or extortion. Count 2, false imprisonment, $2,500. Count 3, operating a business without the proper boating licensing is $150. Count 4, I guess that's using public property for an unrestricted property for improper purpose. That's $150. It's a actually, it's an ordinance violation. I'll do $1 on count 4. Make sure to keep all future court dates, sir. Have a nice day. Next is Christopher de las Torres. Good morning, Mr. de las Torres. Sir, you were arrested for threat. Oh, he's the co-defendant. Threats or extortion, false imprisonment, operating a business without a local business tax receipt, and improperly doing business on public property abutting the water in a restricted area. I will appoint the public defender's office for you. There's probable cause for the charges. Stay away from the alleged victims, Diallo, Osman, and Omu Berry. No contact with the victims, either directly, indirectly, in person, in writing, by telephone, or through third parties, and no contact with the victims through social media or other electronic means. You must stay at least 500 feet away from their home, school, and place of employment. You understand?
Yes.
Oh, I'd love to hear what he's saying. He's saying
Because I
something.
completely understand.
I completely understand. All I know, it's pretty hard to flip a jet ski. I'm sure they flooded that engine. Anyway, that being said, you got to have a license or go work for a company that has a license, okay? Pretrial services alternate bond. I don't remember what I did for the last one. What did I do?
I did 2,500, 2,500, 150, and $1.
Okay, 25 pretrial alternate, 2,500 count 1, $2,500 count 2, $150 count 3, and $1 count 4. Have a nice day. Next, we have Kimon Mays. Hot and cold. Oh no. I got food poisoning.
Thank you, Your Honor.
You're welcome. Good luck to you. Come on, Mr. Mays, come on down. You're next here in bond hearings. Sir, you were arrested for a case from May 24th, and the charge is tampering with the victim, robbery by sudden snatching, and battery. And it shows you're out on felony bond on a case for F-24-25138. So unfortunately, we have to hold you for tomorrow to see the division judge. I am appointing the public defender's office for you. So he punched the victim in the face when I guess he went to the home to pick up the shared child. He also bit her. with her on her arm, leaving teeth marks. He's 28 years old and he bit the victim. Okay. He also snatched her phone and threw it on the ground, causing the back glass to shatter. Probable cause for the charges.
Count one should be a third degree.
Third degree tampering, yes. All right, you are ordered to stay away from the alleged victim, Keziah Jackson. No contact with the alleged victim, Keziah Jackson, either directly, indirectly, in person, in writing, by telephone or through third parties. No contact with the victim through social media or other electronic means. And you must stay at least 500 feet away from the victim, her home and school, and place of employment at all times. Do not engage in any criminal activity. Do not use or possess illegal drugs. And do not use, purchase, possess, or carry a firearm, gun, weapon, or ammunition. You must immediately surrender any firearms, ammunition, and any concealed weapons permits to the nearest police department and file a receipt with the court. Do you understand the stay away order, sir?
Yes, ma'am. Yes, Your Honor.
You got to set a bond. So count one, tampering with a victim. I don't know. So say count one at $1,000. Count two, robbery by sudden snatching will be $2,500. And count three, battery is $1,000. And you'll see your judge tomorrow. Have a nice day. Next is Pedro Costa, page 14. I don't know if he needs an interpreter. We can ask. He's out on bond for F25-17622. There's a hold.
So we're going to continue to hang with Judge Glazer here for a few more minutes. The Creole interpreter's on screen now, and I know that Ashley sounded like she was interested in hearing some Creole, so we'll hang here for a few minutes.
Arrestado por posesión de una sustancia controlada, metanfetamina en cristal y parafernalia para uso de drogas.
There is probable cause for the charge.
Hay motivo fundado para este cargo.
I'm setting a bond. It's $2,500 count one and $500 count two.
Estoy fijándole una fianza, $2,500 cargo 1, 500 cargo 2.
And sir, you're going to have to see the division judge tomorrow because you have a hold.
Señor, usted va a tener que ir a ver al juez de su división porque tiene una orden de detención.
All right. Good luck to you.
Qué buena suerte.
Next is Darren Barreto on page 15.
Spanish, please.
Good morning, sir. You were arrested for robbery by sudden snatching, battery, and criminal mischief.
Ok. Robo al arrancar algo repentinamente, agresión corporal. And what's the third charge? I'm sorry, Your Honor.
Criminal mischief, a first-degree
Daño a propiedad
misdemeanor.
ajena. Okay.
I will appoint the public defender's office for you.
Yo le asigno al abogado de la defensa pública.
So there is probable cause for the charges. This is a case from February 4th of 2025.
Esto es un caso de febrero 4 del 2025 y hay motivo fundado para este cargo.
So you're currently living with the victim, Miss Chrisana, I can't read her name, Flor?
Usted está viviendo actualmente con la víctima, Crisana.
No, estoy tratando de arreglar los problemas con ella porque todo eso fue un malentendido. Ya ella habló con los detectives y todo.
Okay, I'm trying to fix the problems with her because all that was a misunderstanding and she's been speaking to the detectives and everything.
All right, so but because she's not here, right now I have to do a stay away order, enter a stay away order because she's not here to tell me she's not afraid of you.
Okay, ella no está aquí, así que ella no está aquí para decirnos que ella no le tiene miedo. Tengo que emitir una orden de alejamiento.
So, sir, no contact with the alleged victim, Chrisana, is it Flore or Florke? I can't read the handwriting.
¿Cómo es el apellido?
I don't know. Christina State, what's her name?
It's spelled Flork.
Stay away from the alleged victim, Chrisana Flork.
tiene que mantenerse alejado de la presunta víctima Crisana Flork.
No contact with the alleged victim either directly, indirectly, in person, in writing, by telephone, or through third parties.
No puede tener contacto con la presunta víctima, ni directa, ni indirectamente, ni en persona, ni por escrito, ni por teléfono, ni por medio de terceras personas.
No contact with the victim through social media or other electronic means.
No contacto con la víctima por medios sociales ni electrónicos.
And you must stay at least 500 feet away from the victim, her home and school and place of employment at all times.
Tiene que mantenerse a por lo menos 500 pies de la víctima, su casa, escuela y lugar de empleo en todo momento.
Do not engage in any criminal activity. Do not use or possess illegal drugs.
No puede estar involucrado en actividades de delitos. No puede usar ni poseer drogas ilegales.
And do not use, purchase, possess, or carry a firearm, gun, weapon, or ammunition.
No puede usar, comprar, poseer, ni portar arma de fuego, pistola, otro tipo de arma, ni municiones.
You must immediately surrender any firearms, ammunition, and any concealed weapons permits to the nearest police department and file a receipt with the court.
Debe entregar inmediatamente cualquier arma de fuego que tenga, municiones o permiso para portar arma oculta a la estación de policía más cercana y presentar recibo con la corte.
Do you understand the stay away order, sir?
¿Usted entiende la orden de alejamiento, señor?
Sí.
Yes.
All right. State, is he eligible for a program or no? Is he eligible for pretrial or no?
There is a prior domestic violence arrest.
I would
Oh,
ask if you order him into pretrial, judge. It's a delayed arrest. It's from February.
Yeah, but he has he has prior
One
DV
was-
cases.
Right, I think it was a bind down, so it looks like one prior that was bound down.
And it was, and which was then a null for us, judge.
Y la abogada estaba pidiendo que lo dejen salir bajo un programa sin pagar fianza, pero tiene antecedentes de violencia doméstica.
Can he afford to pay for a bond?
¿Usted tiene dinero para una fianza?
No, realmente. El dinero que tengo es para comprarle las cosas a los niños para la escuela.
Not really. The money that I have is to buy the kids' school things.
All right. And pretrial, will you take him? All right, pretrial services, alternate bond. Count 1, robbery by sudden snatching. I'll set that at $1,500. Count 2, domestic battery is $1,000. Count 3, criminal mischief, $150.
Ok, lo voy a dejar salir bajo este programa. La fianza alterna es el robo por arrancar repentinamente, $1,500. Agresión corporal, $1,000 y daño a propiedad ajena, $150.
Have a nice day.
Que tenga buen día.
Next is Tariq McMillan. Good afternoon, Mr. McMillan. You were arrested for aggravated assault with a firearm.
No,
I will-
Judge, this is Mr. Oh, we have the,
Miss Wilson's here.
oh, this is Mr. Exius for the Creole interpreter.
Oh, okay, the Creole interpreters here. Good morning, sir. You were arrested for strong arm robbery. I will appoint the public defender's office for you.
Bonjour, monsieur. Yo arrête parce que te se font voler, yo pral bon avocat dans bureau avocat défenseur public là pour représenter ou.
There is probable cause for strong arm robbery.
Gen bon jan raison pour accusation. Hein?
You are ordered to stay away from the alleged victim, whose initials are JG.
Faut arrêter loin victime nan initial li c'est JG.
No contact with the victim either directly, indirectly, in person, in writing, by telephone, or through third parties.
Ou pa gen lwa gen kontak a victime nan directement, indirectement nan téléphone, voyer message ou bien ou voyer commission.
And you must stay at least 500 feet away from the victim, victim's home, school, and place of employment at all times.
C'est pour être à 500 pieds de victime nan, de côté la l'école, de côté le rete, de côté la travail, tout le temps.
And stay away from the business where the victim works at Rendezvous Salon at 13741 Northwest 7th Avenue in Miami, Florida.
Vous besoin de salon, judge? Rendez-vous salon. Et puis, faut arrêter le côté victime n'a travail là, dans salon, rendez-vous salon, dans 137-41 Nord-Ouest, 7e Avenue.
Okay, you understand the stay away order, sir?
Vous comprenez l'autre café loin, monsieur? I do, but what they said is not true.
These are allegations, sir, so go ahead.
Please ask him not to speak about the facts of the case while we're here in court. I want
Monsieur avocat là dit pour pas parler de ça qui t'est passé pendant qu'on est en tribunal là.
So I'm setting a bond at $7,500.
Caution, c'est $7,500.
Thank you, Ms. Wilson. You're free to go.
Thank you, Judge.
All right, since she's free to go, we'll go too. Let's go back to Judge West's court where there's a rare zebra sighting. He must be on loan from a different jail.
And this is 23 DCCR 2253. Mr. Ibarra's case is set for trial to begin with jury selection next Monday. And what is the announcement?
We'll be ready, Your Honor.
Right. All right, I want to go make sure, let's see, what was the previous, has there been any other negotiations or offers?
It was a cap of 8, Judge. I did let Mr. Jeffries know in docket yesterday before he met with his client that I was open to having further discussions. It's my understanding that it is all.
All right. So I want to make sure you understand, Mr. Ibarra, it's likely your case will be the #1 case for next week, and there will not be any plea agreements accepted after today. Do you understand?
Yes, Your Honor.
All right, and so you want to still go forward with your trial next week?
Yes, Your Honor.
All right, we'll see y'all next week. I will number the cases and let you know after docket, but I anticipate this will be the #1 case.
Yes. I may ask if I could get maybe a protective order. I'm on a trial docket in Polk County as well, not #1, but I'm there.
We'll get that done as soon as it's numbered after docket. We'll get you protection so that you're here, since your client is it anything older or a kid case or anything like that up there? Okay, all right, then we'll make sure and take care of that so that you're good for next week.
Thank you, Your Honor.
Thank you. So just make a note to get that. Ms. Holmes, you have Christina George.
Sherman, we could hold on that one.
Sure.
I'm ready on Mr. Frazier.
Okay. Jacoby Frazier?
Yes, ma'am.
Got it.
I'm ready.
Good morning, thank you, ma'am.
Yeah, that's.
All right, are you Jacoby Frazier?
Yes, ma'am.
And will your client waive the formal reading of the indictment?
He will, Your Honor.
Mr. Frazier, in cause number 25 DCCR 0732, you're charged with the 3rd-degree felony offense of obstruction or retaliation from May 18th of 2025. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Freely.
Okay, did anybody force you to plead guilty? All right. I have here on the computer some documents that have your signature on them that it looks like you went over with Ms. Holmes. Did she explain those documents to you before you signed them?
Yes, ma'am.
And do you understand those documents?
Yes, ma'am.
And do you understand if I follow the agreement that you made with the district attorney that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
And it looks like the agreement that you've reached is for a 4-year deferred probation.
There's 5.
There's 4-year probation and then a $500 fine. Does that sound right?
Yes, ma'am.
And you understand as long as I follow that agreement, you can't change your mind later.
Yes, ma'am.
Okay. And are you a U.S. citizen?
Yeah.
Okay. State tenders number 1.
No objection.
It's admitted. Any evidence that Mr. Frazier is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. find sufficient evidence to find you guilty, but I'm going to reset your case so the probation department can do a pre-sentence report. That'll give us more information about you and your case, and then we'll come back later for sentencing. Ms. Malfino, what is the state's?
I have no
Position.
objection, Judge. He has
Sure.
one misdemeanor evading. I think the PSI will probably come back and show us all maybe some specialized caseload. that
Sure.
benefit him.
So, Mr. Frazier, if I reduce your bond, where would you go live?
6655 Val Street in Gross, Texas.
Who do you live with there?
My grandma and uncle.
Okay, so here,
Actually, grandma owns a house, but she stays there most of the time.
okay. So do you have transportation to go to probation
Yeah, I
and
have
things
this
like
lady
that?
named Miss Charlie. She works at Motiva. She had brought me to court, but tell me to come back, but I didn't come back. But she'll bring me.
Okay,
And I cut grass. I have my own lawnmower.
good,
Weed eater, I couldn't use it, so I gave it away for free.
okay. I don't want there to be any issues with showing up for the pre-sentence for that interview, so I'm probably gonna leave everything the way it is so that we have a good plan in place with that pre-sentence report, and then that way, hopefully there won't be any issues and we'll have all the rules in place, okay? So I'm gonna leave everything the way it is now. We'll see you back here in just a few weeks, and then at that point, you'll get out and be on probation, okay? All right, go back with the bailiff. Mr. Lewis, you have Robert Eaglin.
Robert Eagle. Thank you.
Good morning, are you Robert Eaglin?
Yes, ma'am.
And this is 24 DCCR 2382. Mr. Eaglin's charged with aggravated assault with on a family with a weapon, and case set for trial to begin with jury selection next Monday. And what is the announcement?
Judge, the state needs to announce not ready. I have spoken twice in the last week or so with the complainant. She had a stroke. She actually called me from the hospital.
Okay.
Tell me that she had just had a stroke. She has to do some therapy to be able to be in a position where she could clearly testify. She is cooperative. She understands the ramifications. She's checked in again yesterday, nervous about what my announcement was going to be. The court will see that case. The offense date looks a little bit older. It was originally in CBC. Mr. Laird had it. They could not locate her. At some point, it was then dismissed. When they did locate her, when she saw something on the news or on social media, it was refiled, it came here, so it's actually just been through maybe a setting or two, and this is a first trial setting, so
Okay.
I would respectfully ask for a continuance to allow her to rehab and then be able to.
Okay, I will grant that, and we'll reset it to the next available trial docket. If there's any issues or motions that need to be filed before then, just let me know.
Okay.
Okay?
No problem.
All right, you can go back with the bailiff. Mr. Rojas, you have Marco Gomez.
I don't know if we need him, I'm just gonna be asking for a reset.
Okay.
Issues with the videos.
Why is this one so old?
He got deported at one point and
Okay,
thought
so
it'd be a good idea to come back.
with this pending? Yeah, well, job security. Any,
Judge, Mr. Rojas was looking for a specific video, so Karen was working on that this morning to get that for him. To
Okay.
make sure, because it's a little bit older, some of the videos are different formats, we weren't able to download them like we normally would.
okay,
So she was getting that for him and should have it by the end of the day.
all right, we'll just do a normal reset to give you time to get all those and go over them with your client.
Thank you.
Thank you. And then, you're good. Mr. Nichols, on Jetson Bell, which is actually Mr. Smith's case, that's set for trial next week. I'm obviously going to take into consideration the circumstances. Mr. West is in Tyler County and did announce ready.
I know there's multiple cases. If we need to get one together, we can, Judge. I know Phil's
Yeah.
got everything ready.
Okay, and there, I mean, I would appreciate that. I might number it just because of the nature of the offenses. I would
I'll
think
pick
y'all
one
could
to be ready
throw it
to do it.
together. Okay, not throw it together, but
No,
get one together
I know
based
we
on,
have them prepared and
I mean,
there's
you,
several cases, so we'll pick one that's.
you've got an evading and unlawful possession of firearm by felon, and a possession, all from the same stop, so, all right. Thank you, Mr. Nichols.
Yes, Your Honor.
All right, let's change things up. It's about time to do so. Louisiana, let's see how that's going today.
For the record.
Terrence Terrell, debt 55-11-33.
Thank you. All right, we already had a preliminary hearing in this case, and it was determined that you were not eligible for appointed counsel. Do you have a paper in front of you that you signed during that preliminary hearing process?
Yes, sir.
And that's your signature on the paper?
Yes, sir.
Okay, are you ready to proceed today?
Yes, sir.
All right. I'm going to read the violations, and I'm going to ask you to either plead guilty, not guilty, or not guilty with a statement. In other words, you'll have a chance to explain any plea that you make after we go through the initial violation.
Okay.
So first violation is number 4, that you failed to refrain from criminal activity on or about November 16th, 2024, when you committed battery of a dating partner, theft, simple battery, obstruction of justice. Subsequently, you were arrested by the New Iberia Police Department and charged with those charges. These charges are pending in the 16 JDC, and the trial is set for September 3rd, 2025. How do you plead to that violation?
I no longer have 2 other charges, if I could state that.
You no longer have 2 of them?
Yes, sir.
One you do still have?
Battery of a dating partner by strangulation and simple battery.
All right. And I guess the question is, how do you plead to those violations?
Not guilty.
All right. With a statement, you want to explain why later?
Cause I didn't touch nobody.
Not now, later.
Okay.
I'm gonna give you that option to explain when Mr. Tillis takes over. And the second violation you have is that you failed to make any payments toward the financial obligations, resulting in an arrearage of $630. How do you plead to that one?
Guilty, but
guilty. All right. I'm gonna go ahead and turn your case over to Mr. Tillis. Yeah. Oh, wait, well.
For and against.
All right, Mr. Tillis is pointing out that we have some people.
It is defense.
Okay, we have Brandy Washington. And can we hear from Brandy?
Good morning.
Ms. Washington, you have something to tell us about this case?
Yes, sir. You know, it was all a misunderstanding between me and Terrence that day. You know, and I feel he shouldn't even be in there anymore.
Okay.
Did he push you across the room?
Sir?
Did he push you across the room?
It wasn't across the room. It wasn't a push. The way my house is set up, my floors is messed up. So now I basically trip over it. The rug that's coming up.
Daughter lie. Come on now, answer the question.
Sir?
Are you calling your daughter a liar?
My daughter didn't write a statement
to
say she's a liar.
All right, what about him grabbing you by the throat, strangling you and throwing you to the couch?
He didn't grab me by my throat.
The police officer says that you told her that when she arrived at your house, and the officer advised that there were visible marks and scratches around your neck, and those marks and scratches were photographed.
I can say the scratches didn't come from him because he's incarcerated now, and I'm waking up with scratches in my neck as of now.
But you did tell the police that they were back then.
I
Right?
told her I didn't know where they came from.
Okay, the police said you told them that he
Because
did.
I have nails.
Okay. All right, just to let you know, the police said you told them he did it and that the scratches came from him and that they saw the visible scratches on your neck and documented it as like you told them then. So, got anything else you want to tell us?
No.
Oh, all right. We will next hear from Jacqueline Miller, who's in support, and this would be the offender's mother.
Hello.
Yes, ma'am, we hear you. Go ahead.
Yeah, so that's my son, and broken or left wrist, and I can't maneuver. I'm 70 years old now, and he's the only one that I have that can help me. And so I just want this to just go away because I know I didn't raise my son like that, and I know Brandy came home every day, and we got along fine. And so when this came about, it hurt me to my heart because I don't feel like this all really. I don't know. It just looked like to me it got out of hand. I'm his mother, but I love my son just like any other parent love their children, And I'm not here to say that I was there because I wasn't. I can't lie there because I wasn't there. But I just need him for myself to come home because I can't do nothing in my house. I'm on a lot of medication. I can't do too much of nothing. I can't really cook. That's why I have different people to come and take me to the doctor's offices and all the things that making grocery. And I can't really maneuver in my house because hello?
Yeah, we hear you. We hear you.
Thank you.
Thank you for your help, your statement. The next person we have is Jackie Darby, the offender's aunt, who's on Zoom and in favor. Ms. Darby?
Yes, good morning.
Go ahead and tell us what you have to tell us about Mr. Ledet.
Mr. Ledet is much needed at home. His mother need him, not just his mother, but his children as well need him. I know he had some trouble in the past, but he's a young man, been trying to get his life together. And because of misunderstanding and wrong decisions, things got out of hand. But I believe he truly is learning from the mistake that he's doing. And he's ready to be an asset to his mother, as well as to his children. And also he's willing to be an asset to help out at the church that his mother's attended. So, he is needed by his family.
All right, thank you for your input. That covers the people who are here in support. We have Ms. Cheyenne Wright, who is the supervising officer. Can we hear from Ms. Wright? Morning, Cheyenne.
Good morning.
Can you tell us a little bit about Mr. Ledet's behavior on supervision?
The reason, he wasn't on supervision long before getting arrested. And the only thing I was going off of was the actual police report. I submitted the body cam footage, and so there's that. And then it was just monetary obligations. So those were his two violations.
You did view the body cam footage?
Yes, sir.
And at that point, did the victim say that it was Mr. Ledet who did the?
Yes, absolutely. And the big thing was that they have a clip of the daughter when the officer is interviewing Miss Brandy, and the daughter's like clearly distraught about whatever had happened.
Could you see marks on her neck?
They have a photo that they submitted, and I sent that also. And it's just you could see like discoloration in the skin of her throat, but that was the extent of that.
Thank you. Appreciate you coming on.
Yes, sir.
All right, Mr. Ledette, would you,
Yes, sir.
you have, your chance to tell us what, your version of the story. Good
All right.
morning.
On that day in particular, I was in Generate helping my mother, and she called me to come home, and she came pick me up. A little misunderstanding through a phone, by the phone, and it wasn't no, like, even no fight pursuit or nothing. It was just like I was trying to leave out the door. She got in front of the door, and that was that. I got out the house and took off on feet.
So everything that she told the cops was a lie?
Yeah, Amira wasn't not even in the vicinity of nothing that even took place. And I didn't even put my hand around her neck at all.
All right. And what about failing to pay your fee?
Well, I got hurt on the job August 30th. I came home July 20th. I got hurt on the job August 30th. And I was like the sole provider helping my mother plus her. And I wasn't able to, after I was out of work from August 30th to the date of my arrest, and still under the doctor dealing with my eyes. I got acid in my eyes.
So the answer to the question is you did not pay any fees?
Oh, no, sir, I was unable to.
Right, okay.
Mr. Ledette,
Yes, sir.
you and your girlfriend both said there was a misunderstanding. What was the misunderstanding?
It was something with the phone. I left out the room, and when I came back in the room, it was something about my phone. And still to this day, I don't even know what it really was. Like, me, to be honest with you.
Something with your phone?
Yeah, my phone was left on the bed. I went to the restroom, and I came back, and she was upset.
Okay. So I guess after all of that, the police reports say you guys got in a little tussle and stuff. So you just probably choked her a little bit or what?
No, sir, I didn't touch her at all. I just, like, put my arm on her shoulder, and I moved out the way of the door, and I left out. That was it.
And she called the police?
She didn't call the police. There was someone that was there.
They called the police?
Yes, sir.
Why do you think they called the police?
I have no knowledge, but at the time I didn't have no knowledge, but now I'm hearing that the girl didn't like me for some reason. I never did her nothing.
And her little girl didn't like you either or something? We're just trying to get to the truth. Just more.
No, it was her former friend.
I have no more questions.
I have no question. I have no questions either. So it's time to vote. Mr. Tillis, you first.
My vote is to revoke. These incidents happen, and sometimes they escalate, and I don't know why. Sometimes people come back and tell a different story from the police report, but my vote today is to revoke.
Mr. Freeman?
I concur. I found him in violation of condition number 4. My vote is to revoke.
And I also vote to revoke based on violation of condition number 4 and number 10. And Mr. Ledette, today your parole has been revoked. This will conclude our business at Ivory Parish Jail at 9:04.
All right, thank you, sir.
Denied.
To the great shock of no one, I think. Let's head back to Judge West.
Would there should be maybe an amended motion that comes so that
Maybe
we can go
so.
ahead and include that in
There
everything?
was an email, Ms. LeBlanc from probation followed up with Hardin County, and they stated that they, as of June 30th, had not filed anything further pending, which you can read either there's nothing pending or there's only one thing pending. So it's a drug case, so I don't know if they're saying, well, it's not pending because we don't have a lab back, but
But you think it's been indicted now?
Yeah, she said in the email, she said there's one, she was indicted on March 27th for a second-degree felony possession. That it was set for court in July, but that offense differs from the offenses listed in the MTRP.
Okay,
So the offenses on the MTRP have not been filed.
but there is one that
But there was
has.
one that was indicted in March.
Okay, I feel
it
like,
makes sense because the ones in the MTRP are from 2004 and the March is
24.
2025. But it's
Yeah.
hard to-
so what let's just do, I'm gonna reset it one time. Ms. Malfino, if y'all will get an amendment done, just so that when there's pleas of truths or not true, it's to everything that's out there and there's not any question. I mean, if the other ones aren't coming that are old from 2024, that's fine, but if we've got one indicted, let's go ahead and get it in the motion.
And I know last time she had been hesitant to go to treatment. I will reach out to them and ask if that's something that is ordered, that would concurrently take care of
that.
cases
Okay,
as well.
that would be great. Thank you. All right, we'll get all that tried to, so everything kind of happens at one time, hopefully. Okay? All right, go back with the bailiff, please. Ms. Perazzo, you've got Avion Johnson. It's a sentencing hearing. Good morning. How are you?
Good, how are you?
Oh, it feels like a Monday times 10 on a Tuesday.
Yeah.
Monday, I'm 3 people today, and son decided he needed to pick up the pit bull puppy on the side of the road so it didn't get run over yesterday, and I've been up all night.
Oh, and they cry like babies. I've raised two.
All right, sir, are you Avion Johnson? And this is 24 DCCR 2044. Mr. Johnson was previously in court, entered a plea of guilty to the offense of arson, intending to damage a habitation or place of worship. I've received the pre-sentence report. Has everyone had an opportunity to review that report?
Yes, Your Honor.
Yes, Judge.
Any additions or corrections?
So no corrections, but there is an issue. Ms. Malfino and I have spoken about this. On page 2, at the very top where it says restitution issues, it looks like there's an outstanding bill, if you will, for repairs in the amount of $150,000, but I don't know if that's the actual case. I think that those,
And I would agree, Judge, if I may, Lori,
Sure.
that figure came from the fire department, not from the apartment complex.
Okay.
The apartment complex may be under governmental control, and that may have taken care of the issue. With
Well-
respect to what Marshall Hurdle said in the PSI, I know him very well, actually, and he didn't understand some of the predicament I was in with respect to the complainant, that I had let the court know in advance about her mental status and cognitive ability to testify, etc. If you would like me to take a deeper dive into where that restitution is owed, if any, that's obviously way substantial amount to order Mr. Johnson. I am concerned about his behavior.
Well,
while awaiting
I'm
sentencing.
concerned about his behavior, but I'm just as concerned about the fact that he denied the
He blamed it
offense.
on her, right?
yes.
So if you didn't do it, then you shouldn't have pled guilty. And so that's what a jury's for, to come in and decide if you are guilty or not. This says, at least what they put in here, that you said that there was a bottle of lighter fluid on the floor, that she flicked a cigarette and the fire just started, which is different than what That's obviously not arson, that's an accident. And so, we've got to get past that before we do anything else. So either you did what they charged you with, which is starting it in anger or whatever else was going on, and, or not. So, did you do it? Did you not do it?
I wouldn't say I did it, but I would say that contributing it to it. We were kind of wrestling and it just happened.
Again, that sounds like an accident, not arson. Because here's the thing, I mean, a 5-year deferred probation is a great deal. I mean, you don't have, I mean, well, I say that, you do have criminal history and a revocation. So I don't know what we're doing. Anyway, if you violate your probation later and you're back in here on a motion to revoke, I mean, it's a first, right? I mean, you're looking at 5 to 99. And if I say, you know what, I think you deserve 25 years in prison, you can't say, well, I didn't really do it back then. I shouldn't have pled guilty. So you're stuck. So either you did it or you didn't do it. You know, when you were here before, you were standing in front, you stood in front of the clerk, you took an oath, you said, you're going to tell the truth. And so telling the truth is either accepting responsibility if you did it or saying it was an accident. And if it was an accident, it's an accident.
But I played out to it, I played guilty to it, and I accepted the charge for arson. I understood what I was doing, so.
Okay, all that's great. Did you do all of that because you're guilty of the offense?
Yes, ma'am.
Okay, so I guess what we need to do at that point, then I don't mind. The only problem is I need to have that restitution before sentencing.
Yes, ma'am.
But I don't want him, if he's getting a deferred, he didn't need to be sitting in jail.
An idea might be, if I may, Judge, to order not to exceed that amount. I will confirm, and then we can
Sure.
drop
That's what I was
it
just
to.
about to say. You've done that before.
Yeah, that's probably the easier way to go ahead and get it sentenced so you can get out. Obviously, I wouldn't expect that it would be anywhere near that, though. I mean, that would.
If you understand my position.
Sure,
of what I'm saying
absolutely.
about what
I
it
do.
was.
Yeah, and then if you, if there's an issue when the restitution amount, if any, comes out, and we need to have some type of hearing on that, then we can still do that even though he's sentenced if I do a not to exceed amount.
Yes, ma'am.
So do you understand, Mr. Johnson? What I'm going to do is go ahead and give you the probation today. I'm going to order restitution not to exceed $150,000. No one expects, I don't think, for it to be that, or maybe, who knows what, maybe not anything, maybe much lower than that, depending on insurance and whatever else. If there's an issue with that, we can handle it later, but that way we can get you sentenced today and you can go ahead and be released. Do you understand? Now, if there is restitution, and you will be required to pay it on that probation, so it's really important that if there is any ordered, that you start making payments on whatever it is, every single month, even if it's just a little bit, to show me that you're making those payments, okay? So what I'm gonna do is find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney. Defer all proceedings for a period of 5 years. There will not be a fine in your case. There will be restitution ordered in the amount of not to exceed $150,000. Now, I have a note here that if I accept this agreement, there might be something else I do because of your jail incident reports. You know, I mean, you were just in a fight in July out there. June, talking disrespectfully to, I'm not real sure what's going on in the jail to make any of you that are sitting in jail thinking that the correctional officers are going to somehow have anything to do with you when you get out of jail. I mean, really, you think that's where you're going to meet your next girlfriend?
No.
Then you shouldn't be talking to them like that, right? I mean, you threatened one male officer that you were going to beat his ass.
say something a little bit.
I don't know, you probably shouldn't. How old are you?
32,
You're too old to be acting like this. This is the kind of stuff I'm getting on the little young punks out there. You know who I'm talking about, all of them that are out there acting like heathens. That shouldn't be you. You're not doing near as much as all them, but I shouldn't be having this on somebody that's in their 30s. I mean, you've already been on probation and know what it takes to be on probation and didn't do it. So I hope that by going forward today, you understand, just like I said, if you follow all of the rules of this probation, great opportunity, right? You don't have this conviction on your record, you get out, you live it like the rest of us. If you violate any condition of probation, you're brought back into court, you become a convicted felon on this case, and I have the whole range of punishment, which is 5 to 99 or life. And I'm gonna look back at that time and see that I gave you an opportunity on probation when you just revoked a probation 2 years ago. And so it's probably not gonna be some little mountain prison and you just get to go on your way. It's gonna be, you need to start learning from your mistakes kind of thing, right? Make sense? All right. So I'm going to hand you the trial court certification that shows this was an agreement that I followed, so you've waived your right to appeal. Probation will give you some information today before you leave. Make sure as soon as you get out, first thing you do is go to probation, okay? All right, good luck.
Thank you, Judge.
Thank you.
Let's change things up a little bit. Let's stare at some animals for a couple of minutes because we haven't done that in a couple of days. This feed is courtesy of Tiny Kittens HQ. In reading the story, it sounds like there are 6 kittens here, and the mothers are sisters. Squeaky gave birth on May 26th. 3 of the kittens passed, but 3 remain. And her sister Squeaky on the 29th, or no, Lily, excuse me. Lily's sister on the 29th gave birth to 5. Sounds like they were preemies. 2 of them didn't make it, but there are 3 remaining, and both of those cats are rescues. So these are kittens of a couple of rescue cats, and they're active. They're all sorts of spunky, all sorts of fun. So I like to show these things because it's a good break from court from time to time, and quite honestly, I like these organizations that are trying to help out and try to do right. So yes, Tiny Kittens HQ, 256,000 subscribers on YouTube. So give them a look. Let's see where we want to go next. I was going to go to Judge Simpson, but he's done and deleted his stream already. Because we can't leave a good thing up for too long. Let's go ahead and go back to Judge West.
Williams is charged with capital murder, and Mr. Cashin, you represent him on that case.
Yes, Your Honor.
Mr. Johns was hired to represent Mr. Williams in cause number 24 DCCR 1790, which is the aggravated assault causing serious bodily injury.
Yes,
we're here today on an announcement. Mr. Cashin has filed several motions, and so a couple of things that I feel like we could probably handle today, and then a few things that I'm going to put off to another day. Most of those motions I think were filed Friday.
Yes,
Mr. Smith is the Assistant District Attorney on the case. You can talk with Ms. Malfino this morning. She'll kind of fill you in on how I guess let me go through the first thing with regard to discovery.
Yes.
And how you get that here. There's a portal. It's very easy. The state is very easy to deal with. They'll give you access to that portal. If there's any media in the case, there's a different request that needs to be made for that. Ms. Malfino can sit with you this morning and explain how all of that goes.
Yes.
So with regard to it, this time discovery, I'm not going to rule on any discovery motions. It's automatic. Michael Morton Act and everything else makes it where they're gonna give you everything they've got. And so if you find after you visit with them and you get everything off the portal that you feel like there is something that's missing, then bring it to my attention, bring it to their attention first, obviously. And if there's an issue that you feel like you're entitled to something that they're not turning over, then we can have a hearing on that at that time. So the next thing that I do want to go through and rule on, at least today, is that motion for a gag order that was filed some time ago, and so everybody's had a time to take a look at that. I'm going to, Ms. Malfino, I guess let's start with you. Obviously, I understand Mr. Cashin's position with regard to that and his motion. What's your position?
I do as well, Judge, and I think the court is aware, as long as you've known me, myself and Mr. Smith, it's always our best practice policy not to speak to the media or anybody while a case is pending. If that, I have no objection to that order, and if it is granted, I will be sure to send out a memorandum to my office, letting them know it has been granted and that they need to comply.
Sure, and I don't have an issue with the district attorney's office. The only issue that I have is the sheriff's office.
Yes, ma'am.
Because I don't think the sheriff, typically, as everybody knows, gag orders are not deemed constitutional. Obviously, there's exceptions, and Ms. Malfino agrees in this case with regard to her office. I will gladly ask the sheriff's office, but I don't think I'm in a position to order them. They are not a party, as the attorneys are, and so I'll let you make argument if you'd like, but I'm not inclined to grant a gag order on someone that's not a party. I don't think constitutionally I can do that.
I understand, but I just wanted to point out to the court that certain people in the sheriff's departments, I think they have podcasts and they go on the media and then they give their opinion about this case that is presently pending, which I kind of think taints the jury pool if we end up in a trial. And
Do you know who that is? Somebody who has a podcast currently about this case?
Well, I've seen sheriffs speaking about this case on different broadcasts. If I need to be specific, I will locate those particular or that particular.
If you don't mind doing that, and you can, if you would, you can just email myself and Ms. Malfino, Mr. Smith, because I don't mind at least starting with a request to them not to do it. If I feel like what they're doing is in some way going to be detrimental to us being able to get a jury, then I will look more into that. I don't know, again, the constitutionality of it. I would have them probably show up to a hearing with their legal representatives and we can handle it that way. So let's do that. At this point, I'll grant the motion in part with regard to the district attorney's office and obviously with regard to you, Mr. Johns, and anybody and everybody's, y'all's respective offices. And then send me that and whatever information you can find. I'll talk to the sheriff's office. I have a feeling they won't have any issue with my request. And so, but if they do, then we'll talk more about that. So then that's that.
Also, Your Honor, I think some housekeeping matters that I think are rather important is in regards to the indictment and the way the indictment.
Yes, so you filed a motion to quash the indictment. I did take a look at that. I honestly saw the same issue already with the indictment. The style or the heading of the indictment legally is not necessarily indicative of the most important part, or it doesn't, what's the word? The body of the indictment sounds correct in this case. The state has become aware of that. It should say A2 instead of A10. They are going to get that taken care of, and so that way it looks correct. It's correct, obviously, in our system as well, which can become an issue just because of our system.
And I just want it to be correct.
I totally agree. And that's the only issue, was the A10 to A2, correct?
Yes,
okay.
Yeah, that's rather important.
It is. The body, though, I did read the body, and it looks like there's not an issue, but we'll make sure that the Ms. Malfino.
And Judge, having not worked with this gentleman previously, I would be happy to make an oral motion to amend if you would prefer.
It
That
doesn't
we
matter.
follow that up with a written motion, just so it's cleaner for the court. I'm
I think
happy to
I'd
do that
rather,
as well.
just because of the nature of the offense, because it's a capital, if we just do that, if y'all would do a motion in writing. And that way we've got a paper trail
Yes,
in the file that shows there was a motion that's and I'll grant that and make that adjustment on the
I just
indictment.
want it to be accurate.
I don't disagree with that at all. So they'll get that taken care of, I'm sure, very soon.
It's gonna be e-filed, sir, so
Okay.
if we can exchange emails, I can be sure
We'll
that
do
it's
that
served.
after we conclude.
It looks like the other things that were filed have to do with, mostly discovery issues, a list of persons to contact or interview, some
Yes,
things
and
like that.
That to me, Your Honor, is important because after reading the probable cause affidavit that's attached, it indicates a lot of he said this and she said that, and
That's one of those things that I would say, get with the district attorney's office. Obviously, I would think anyone that any detectives or officers talk to or interview
Yes,
would
ma'am.
be part of required discovery.
and I would like that, like, kind of like early on instead of later on, because those people
Well,
need to be interviewed.
Sure, I mean, whatever they have, you'll get.
Thank you.
And then if there's anything, again, that you feel like is not included,
I will
bring that to their attention first. Let them contact the agency,
Yes,
see where that stuff is and how quickly they can get it. And then if it becomes an issue, let's get back on that.
Yes,
The last thing that I see that I'm not there's a motion for preservation of personal notes.
for the officers, the police officers.
Okay. Ms. Malfino, have you had an opportunity to take a look at that? I really haven't, as far as,
I really haven't, Judge. I know that.
I would think
you know,
personal notes might fall into some type of
of
work product. I mean,
is-
their reports
if
obviously
something
will
was
be turned over.
exculpatory, yes, I would agree that, you know, that information be turned over. I would assume it would have then been placed into a report.
Right.
At some
Mr.
point, I
Cashin?
would argue that some of that is work product, personal notes of correspondence between us and the officers in preparation, et cetera. I would argue is work product.
To me, the personal notes are attached to the people that have been interviewed, because the officers, when they go out and interview people, they may take personal notes, because in the probable cause indictment, it said that they had spoken to certain people who said that he had a gun on a particular occasion, certain people that said he did it, and those are the people that need to be interviewed, and the personal notes of the officer relates to those things.
And Judge, if I may, I think he may find when he requests the media that majority of those interviews
On
might
body
possibly
cam.
be on body cam or having someone come into the police department.
Right.
It's not so common practice anymore for the transcript, so to speak, of that interview to be recited then in a report. So it may reflect in the report, I spoke to X and he hasn't seen the recorded interview, which would obviously make a big difference.
Okay.
But that's the type of information I was leaning toward.
Sure. And I think that's probably, let's do
And
this.
with the nature of the case, I need to cover my bases.
Absolutely, no, yeah, I would totally agree. So today, what I'm going to do is hold making a ruling on the motion for preservation of personal notes. The motion for discovery, obviously, that's granted, you get all of that, work with them. Anything in the person's interviewed, let's go through the discovery process first, the way, with the portal and everything. If there's anything that comes up that you feel like you're entitled to, that they are refusing, then we'll have a hearing about that and work that out. The last thing is there's a motion to reduce bond that was filed on Friday.
Yes, ma'am.
And so, Ms. Malfino, I'm gonna ask, is the state ready to proceed on that today, or do you need some time or to get Mr. Smith available on that one?
Well, and I'm happy to cover it, Judge. I don't need a lot of time. I would prefer the ability to get at least the lead detective here for the court.
Sure.
In the instance that you or counsel would have any questions with respect to that. I'm not necessarily saying we're opposed to some type of relief. I know what the bond is set at now, but I think due to the nature of the case,
Sure.
as counsel has stated as well, I think it might be beneficial to have just a very short hearing. I can be prepared on that as early as next Tuesday, Judge.
Okay, so Mr. Cashin, we can do a couple things. I think just because it was filed kind of late in the game.
ma'am.
I want to give them just a short amount of time to get prepared on that. We typically have Tuesdays are our jail dockets. I'll be in,
Or maybe the next week, since we're gonna be in trial next Tuesday, we won't the following week because of Labor Day.
Right.
That would be great.
Mr. Cashin, I'll let you choose next Tuesday or the Tuesday after.
Maybe on my calendar right quick.
We could do it next Tuesday. Do we have one already set at 11 next Tuesday? We'll do a lot of these types of things at the end of our Tuesday dockets. We might have something already. We do not. So we could do it either or next Tuesday or the Tuesday after.
Tuesday afterwards might be better, September 2nd.
September 2nd?
Yes, that'll work better for me because I have several matters next
Sure.
Tuesday.
Okay, then we will set the motion to reduce bond on the 2nd. And if anything comes up between now and then, we can discuss all that as well. And especially if, Mr. Cashin, if something comes up after I visit with the sheriff's office with regard to any information that you emailed to us,
Yes, ma'am.
then we can maybe have them here on that day possibly to take care of that part. But right now I am granting the part of the motion for gag order on the attorneys only.
Yes, ma'am.
Okay, anything else we need to handle today?
I think that covers
The
it.
status of my case with him, prior to these new allegations, we had come to a proposed plea bargain agreement with Ms. Smith.
I won't, at this point, I don't think it's appropriate for me. I'm not going to accept any plea agreements
I
on that
understand
case.
I'm just kind of giving you the background.
Sure.
Let you know, I have been talking to Mr. Smith. I talked to him last week in reference to this case, some of the suggestions that he made to me. I really don't know where to go forward with this situation, so I would ask for more time, so I can see what's going on.
I think that, sure, and I think what we'll do is carry the two, they're obviously not on the same date, cases, but they're related. And so the cases will be carried together on all of the dockets. And if, on next Tuesday or the Tuesday after, that's really a motion that Mr. Cashin has filed that we're going to handle. If you want to be here for that, you're welcome to. I don't think legally you haven't filed anything that we would be hearing on that day. It would be the bond reduction. But typically on announcements and as we're preparing to move forward in the case, I would expect you both to be here. Both cases will kind of travel together and then we'll see where we get.
To add to that, I appreciate you saying I don't have to be here next Tuesday. I'm at a stage in my life with my mother. I'm blessed to have my mother at 94 years old. And you probably can make an anecdotal effect that I'm pretty much steady going to be in court when I'm supposed to be in court. But because of that, I'm having some issues and I'm not getting where I need to be getting it. The secretary's gone. So I'm having a few little anecdotal issues right now, which I haven't had the last 30 years.
We'll make sure, again, on the 2nd, you don't need to be here on that one. After that, you'll get notice of obviously every announcement and things like that. And so if you're having an issue, just let us know. If it's something that's just an announcement, it may be something that you can visit with Mr. Cashin. If there's nothing that's taking place and you're having an issue, we can still move forward, at least with moving the cases along. All right.
Thank you, Your Honor.
Thank you.
That's one other thing that in reference to discovery issues, the discovery portal is absolutely fantastic dealing with. But these TFI files that they file instead of using the PDF files, they were almost impossible to open them. Okay.
All right, so I don't know the letters you're saying, but get with Miss Malfino and Mr. Smith.
She can't fix
anything. I'm sure that if there's any issues that you're having with a specific file, they'll get that for you. Just get with them.
I don't know if that's possible. They might have to go upstairs to the computer department. But thank you, Your Honor.
All right, yes, sir. Thank you, Mr. Cash and Mr. Williams. You can go back with the bailiff. Yes, sir. Nice.
So I gotta say, the whole discussion about gagging a podcast there was absolutely horrific to me. The fact that it would be suggested, but then as well, the Judge West, she should have just poo-pooed that right away. But she's like, well, I don't know the constitutionality, but we'll look at it. Maybe she's just trying to be nice, but she knows the constitutionality of it. The answer is a flat no. freedom of speech, freedom of the press. Need I go on? What a bunch of hooey. Perhaps this is something we'll discuss on Sidebar at some point, but not tonight. Sidebar tonight is about how AI is writing police reports. Check it out. It is, I believe, one of our best shows, if not the best. 8 p.m. Eastern, 5 p.m. Pacific, right here on this channel. Let's stay in the building. We'll go back to Judge Stevens. Who once again is muted. It is Mute Tuesday here at TCF. I don't know what is up with these judges, but nobody wants to be heard. Let's try Louisiana.
And to my right, the panel still here at headquarters, and our remote location is DeSoto Detention Center. Is there any staff in the room with you? Can you unmute? We can't hear you.
No, sir.
No staff? Okay. Then give us your name, full name, and DOC number for the record.
Don Pedro Wilson, DOC number 530-137.
Okay, I'm looking at your notice of preliminary hearing, and it was determined back then that you were not eligible for appointed counsel then. So that would mean you're not eligible for appointed counsel now. I'm going to go ahead and read a list of violations to you and ask you to tell me if you're guilty, not guilty, or guilty with a statement. Number 2 says that you failed to report to your parole officer for the month of February, March, April, May, June, and July of 2025. How do you plead to that violation?
Guilty. With a statement.
Okay. And number 3 says that you moved from your listed address and failed to provide your parole officer with a valid address where you could be contacted. You absconded supervision and a parole warrant was issued. How do you plead to that one?
Not guilty with a statement.
All right. And on or about July 3rd, 2025, you got a ticket for speeding and driving under suspension. How do you plead to that one?
Guilty.
All right. You wanted to make a statement, so I'm gonna sign your case, so I'll go ahead and see it from here. What kind of statements you want to make in regard to number 2?
I had started a job, and my job consisted of me being gone away weeks and weeks at a time. That's why I wasn't at the address. Like, I never moved.
You never moved, you just wasn't staying at that address?
No, the job I had started, it consisted of me being gone weeks and weeks at a time. That's why I was never there. That's my address.
So did you make your parole officer known that?
No, I never contact. No, sir. I never made contact with her.
Do you see how that could be a problem?
Yes, sir.
If you were to get a break today, what would you do differently?
If I contact her, I let her know that I started employment and like what was going on with my situation.
All right.
As far as
anything else you want to say about number 2?
Like I don't see how the February was my last February. That was the last time I went. I know for sure that it was the last time I went to court. I came March, but something had come up while I was in the parole office, so I had to leave. I remember I asked the woman, "Can I leave and come back?" But I never made it back. So in July, I don't see how I missed July. I was locked up the beginning of July.
Well,
you
didn't report. It's not really totally incorrect.
Yeah,
the whole point is about reporting, and you admit you didn't report, but your reason was that you were working.
Yes, sir. I have wrote a letter to the board and to my parole officer.
I saw that. All right. You got enough about number 2 in there, I think. And then number 3, you moved from your address. You're saying you didn't move, right?
No, sir. I just started work.
Okay. And then speeding, you plead guilty to that.
Yes, sir.
Right. I'm looking. We have some people here in support of you.
Yes, sir.
Let's hear from Miss Lily Wilson first, cousin.
Yes.
Go ahead, Wilson, tell us what you have to tell us about Dawn.
Hold on. You can hear me?
Yes. Yes.
Yes, I feel like he should be released because he was trying to change his life around. He had got a job and he also have a daughter at home waiting on him, and she called us every day about him. And like he really was trying to change his life around.
Well, thank you. Take that into consideration. We also have Miss Rayfield Wilson, a cousin.
Yes, sir. Mr. Rayfield Wilson.
Okay. Okay, see. Okay, go ahead and tell us what you got to tell us.
Yeah, that's my cousin. He's a good person, man. Like he been incarcerated like 12 years, and he came home on the right path, you know. And when he came home, I mean, while he was incarcerated, he kind of lost his dad and his mom. He been like around me like since he been home, and I can see him doing better. Okay, he probably did make some mistakes not going to see his PO and stuff like that. But at the same time, he was working, so he have a reason why. But I feel like he should have like reached out to her. But if y'all give him another chance, I feel like he'll do better and understand. You know, he's a good person. He ain't catch no new charges. Like he got a speed ticket, but that's not nothing. I feel like this serious should hold him back or nothing like that.
All right. Thank you for your input. Appreciate it.
All right. Thank you, man.
All right. That's all the supporters we had here. We have no one here in opposition.
Jesse Bacon. Employee. Jesse Baker.
He was maybe, yeah.
Oh, Jesse Baker. Okay. Is he Baker?
Excuse me. This Raphael was Jesse Baker is his boss. I just got off the phone with him. He's like working right now. He was trying to make it, but he couldn't. I guess he's kind of busy right now.
Okay.
That's his boss. His who he worked for.
And basically, what would Jesse have to tell us? That he's going to give him a job if he gets out?
No, he have the job right now, waiting on him. He's waiting on him to get released or whatever. He's waiting on him. That's basically what he was gonna tell y'all, that he worked for him. He was arrested when he was with his boss leaving the job. Okay. That's how he got arrested, with his boss.
All right.
Yes, sir.
All right, Mr. Wilson. If we were to let you go, would you report to your parole officer monthly?
Yes, sir.
No questions asked. You got that clear message now, right?
Yes, sir.
Not gonna be tolerated. You got to report.
Yes, sir.
That means you actually talk to the officer, see the officer, fill out your report. You don't just go to the office and say, I'm leaving, I can't stay.
Yes, sir.
Your boss obviously is gonna understand that need to do that too, so he ought to help you out with that. All right, I have no questions. Does anybody have any questions?
I don't have a question.
All right, I'm gonna be the one to cast the first vote, so I'm gonna go ahead and vote to reinstate your parole, give you another chance in order that you follow all the conditions of parole, including the reporting monthly.
Yes, sir.
Mr. Tillis?
My vote is do not revoke.
Mr.
My vote is to do not revoke, reprimand, and continue on supervision.
All right, Mr. Wilson, your parole is going to be reinstated and you're going to be continued on supervision. And remember, reporting couldn't get you in jail.
Yes, sir. Thank you all.
Good luck to you. This concludes our business in DeSoto Parish at 9:21 a.m.
Denied. Approved?
All right, my boy.
All right, come get me.
Denied. Approved?
OBS couldn't believe it so much that it had to play it twice. Weird. So there is not a lot going on out there at the moment. There's a lot of courts that have gone to recess, others who have completed their docket for the day. So we can visit some places that we don't normally go to. As a matter of fact, let's do this. Let's go. This is Thurston County, so the Olympia, Washington area. This is a court we've never visited. Let's see what they're all about.
Tuesday, August 19th, 9 o'clock calendar. It's 9:08. We'll start now. Ma'am, I don't know your name. Would you please tell me?
Good morning, Your Honor. My name is Kokoro Kirikina, and I am Rule 9 with the Thurston County Prosecuting Attorney's Office.
Thank you. All right, so who do we have ready to go today?
I'm ready, Your Honor.
Okay. And you're here for Mr. Irinella today?
I am, Your Honor, and my client's name is Matthew Beyer, B-E-Y-E-R.
All right, number 1 on the calendar. Thurston County versus Matthew Beyer, B-E-Y-E-R, 4A0902070. It's a second pretrial for driving while license suspended in the 3rd degree.
Yes, Your Honor, I believe there's also another case number, 5A0321935, that's also on for today. They're both DWLS 3 charges.
Sorry, I didn't call that one.
No worries. We are just asking for a continuance today so that he can get relicensed. He hasn't yet been able to work out all of the things holding his license. We're willing to waive speedy for purposes of this request and will appear on his behalf under 3-4.
Any objection to that?
No objection from the state, Your
All
Honor.
right. All right. Upon the submittal of a waiver of speedy trial with today as a start date, and looks like end date would be November 17. If you submit that, we will continue both case ending in 2070, which is Thurston County matter, and case ending in 1935, which is the City of Yelm matter.
Yes, Your Honor, thank you. I'll submit that waiver imminently.
All right. Do we want to set a date now or let Becky set it? All right. We will have the calendar clerk set that date for you and send that on to you. All right.
Okay. Thank you very much, Your Honor.
You have other cases on?
Nope, that's all I have.
All right. Thank you.
Thank you.
Mr. Laverns? Case on today?
Sir, I'm a defendant. I'm waiting for my attorney.
All right. Mr. Talmadge, you're waiting for somebody too?
After Your Honor.
All right.
Your Honor, this is Igor Shapiro. I'm present with my client, Preston Curtis.
All right. You were going to be my next call.
Perfect, Your Honor.
Number 6 on the calendar, Thurston County versus Preston Curtis, C-U-R-T-I-S, case number 5A0369125. It's first pretrial, 1 count of carrying concealed a pistol without a permit. Mr. Curtis, how do you wish to proceed today?
Your Honor, we're going to be asking for a motion to continue. Mr. Curtis is currently working on a couple of things so we can try and negotiate his matter. And we did upload that continuance.
Should we just leave it set for confirmation and trial and go from there? Or do you want to submit a waiver?
I think we already submitted a waiver, Your Honor.
Look.
Thank you.
All right, looks like the waiver was filed yesterday, so we will reset this for pretrial and have the calendar clerk send you notice as to what date that will be. Looks like that.
Thank you, Your Honor.
Should expire somewhere around November 15, 17, somewhere in that neighborhood.
Okay, sounds good. Are we free to go?
You are. Thank you for being here.
Have a good rest of your day.
You as well.
Thank you.
have Attorney Shannon Poley.
Michael, I agree with you. He is a very tired looking judge. He looks like he's been on the bench for 80, 90 years, maybe. And that's not me being critical. I just think I think he's ready to retire. Go enjoy his great-great-grandchildren. Let's go to Colorado, give them a try. This is Loveland, Colorado. Let's see what's going on there.
Miss Garza has pled guilty in a case in Boulder County and she's awaiting sentencing. Other than that, I don't believe she's not serving any other sentence.
Well, there's a bunch of 23 cases in Weld County. Is that?
Those are unresolved.
Pardon me?
Those are unresolved.
Okay. Then, is there a stipulation regarding factual basis?
Yes, there is.
Ms. Garza, are you happy with the assistance of your attorney?
Yes, sir.
What is your plea then to original count one, possession of a controlled substance, guilty or not guilty?
Guilty.
Court will find that Ms. Garza appears to be competent to proceed. She understands the elements of this offense, possible penalties and sentencing alternatives. She understands her rights, including her right to trial and to appeal. She appears to be knowingly, freely, and voluntarily waiving those rights. He does not appear to be the result of undue influence, force, or coercion on the part of anyone. Factual basis has been stipulated to, so the plea will be received. Conviction enters as to count one. Remaining counts that exist are dismissed. And comments prior to sentencing?
We would just ask the court to accept the agreement. Think, this case, it's an older case, and I think in large part, the circumstances that led to Miss Garza being arrested and how old it is just had a lot to do with her struggle with addiction. Miss Garza has been at the Boulder jail now for almost 4 months, I think. And I know at that point she's been working really closely with the reentry specialist. That's actually how I found out she was at the Boulder County Jail, because that person reached out to me. I know that they're working closely in helping her get treatment while at the jail and look towards treatment when she gets out. My understanding is that she's looking at a possible community corrections sentence in Boulder County, and is just, I think, really hopeful to turn her life around and work with community corrections and engage in treatment there as well. So we would ask the court to accept the agreement and authorize or grant Ms. Garza the 90 days of pre-sentence confinement credit. A warrant issued in this case in January of this year, and she was arrested and held in jail in Boulder since May 1st, which would give her over 90 days of credit. We would ask the court to find that there's a substantial nexus there and grant the pre-sentence confinement credit. That's the intention of the parties. Yeah, I think that's all.
People?
Your Honor, we would join Ms. Alberti in that. It came to our attention just recently that we are not technically supposed to be nunc-pro-tunking certain sentences as well as this. However, the intention of the parties, and given that there was a substantial nexus, we do ask the court to grant the 90 days credit for time served.
So the court would accept the agreement to include the credit for time served, but would accept the credit for time served separately on the grounds, not so much a substantial nexus because she wasn't held on this case. I'm not sure there is a substantial nexus. On the other hand, the court would also note that Boulder is unfortunately in the habit of not holding our misdemeanants on their warrants. And court does not note in the court file that the warrant that Ms. Garza was detained on the warrant at any point in time. So because of that anomaly, the court would accept the agreement, sentence Ms. Garza to 90 days of jail, 90 days pre-sentence confinement credit is granted, leaving no more days remaining to serve. And although it's academic, court notes that the time is straight and begins immediately. The court does not impose a fine, costs, or assess, which include the $1,000 drug offender surcharge. Is there anything else we would need to take care of today from either attorney?
No, Your Honor.
No, Your Honor. And Ms. Garza, did you have any questions about any of this?
No, sir.
And that will be all. Thank you.
Thank you. Your Honor, this is the
All right, let's go back to Louisiana. We will finish our day with an attempt to break our tie of one approved, one denied.
My colleagues on today's panel are Mr. Tillis to my left and Mr. Freeman to my right. Today's panel is at headquarters in Baton Rouge, and our remote location is the Louisiana Transition Center. Would staff at the Transition Center please introduce themselves for the record?
April Cootie, Program Director.
Thank you. And we have a hearing on Ms. Hopkins. Ms. Hopkins, would you please give us your full name and DOC number?
This is Miss Caslot. I'll get Miss Hopkins. I'm sorry. Teresa.
Okay.
I saw Caslot as next. I'm sorry.
All right, no problem.
It's a quick fix.
Okay, good.
All right, have a seat.
Ms. Hopkins?
How y'all doing?
All right, would you please give us your full name and DOC number for the record?
Teresa Marie Hopkins, 499-862.
All right. I'm gonna give you a brief explanation of the process. First, I'm gonna read some information into the record and ask you to verify it. Then we're gonna give you a chance to speak. I'm gonna ask you to tell us what caused your incarceration and why you should be released. We'll ask for information from the warden or the facility people to speak, and then we'll allow comments from supporters and opposition. And then we'll conduct a parole interview.
You can scoot up.
So today we have for parole consideration Teresa Hopkins, whose DOC number 499862, who's a second felony offender who was convicted of manslaughter on May 20th, 2013, and sentenced to serve 35 years in St. Tammany Parish. You have a parole eligibility date of November 26, 25. You have a good time date of March 25th, 34, and a full term date of June 20th, 40. Does that information sound correct to you?
Yes, sir.
All right, well, go ahead and tell us, what did you do to get yourself in jail, and why do you think now would be a good time to release you?
I was at a drug house, and a lady somebody got killed, and I was there, and they said I had a part in it. They say I had gave them the murder weapon to kill the lady.
Did you?
Yes, sir, I did.
Okay. Anything else you wanted to tell us?
That's all, sir.
She gave the murder weapon or Chrissy, that's what she was into.
All right. I don't see that you have any attorney present to speak for you. Can you have the warden or the jail staff to tell us how you've been while you're incarcerated?
I'm April Cootie. I'm the Program Director. I have had Teresa here with me since 2013. She hadn't been a problem. She's taken every class that she's been able to take. Just works, she gets a job on compound and works. And she has tried hard to better herself with classes and anything that we've asked of her.
Thank you. I see we have in support Ivy Mathis with a reentry specialist. Miss.
Yes, sir. Good morning.
Go ahead.
Yes, sir. Good morning, board members. My name is Ivy Mathis, and I am a reentry transitional specialist with VOTE, which stands for Voice of the Experienced. We have a transitional home that we are willing to take Miss Hopkins in as a client, where she will have all the necessary benefits and resources to help her get acclimated. We offer 6 months up to a year, depending on each case. We do know that every case is different. Everyone acclimates differently. I will work closely with Cornerstone Builder Program, Catholic Charity, set up with a bank account, driver's license, teacher processing freedom, debit card, all of the things that she will need. And also get her additional help if she needs it once her assessment is done, should she be successful today at this hearing.
Thank you very much. All right, that's the only person that we had here in support. We have several people here in opposition, and I'm gonna go ahead and list them. We have Miss Regina Spencer, the victim's cousin, who's opposed but not speaking. We have Keith Ford, victim's cousin, who's opposed but not speaking. We have Cedric Robertson, the victim's nephew, opposed but not speaking. We have Antoinette Redmond, victim's cousin, opposed but not speaking. We have Jeffrey Edwards, the victim's son-in-law, opposed but not speaking. And we have Thomas McMillan, victim's friend, who's opposed but not speaking. We have Denzel Olson, the victim's son, who would like to speak, and would ask him to go to the podium now. Take your time.
Some of them are when I try to look at this and I try to get it. I don't know what it's like. My mom was I had no father. It was me and my mom. And in the most early days of my life, you stole the most important person to me. And I had to grow up so confused, so lost, so hurt, until everything is never here. To know that you're a mother who was only around you because she could give you all the shit off with them. I don't care if you say she was my mother. I'm not moving from everything for me and my son. And regardless, I was serious living at the home. And you took the most precious gift. And because of it, I'm knowing that son. I want you to understand what's happened since. My older brother, which is found, had to identify my mother in both bruises as it being left out of the city. Body changing color. Imagine what that does to a 19-year-old kid trying to transition with being a mom. 7-year-old boy is trying to recover. We never recovered. My brother has now, just speaking of this in my head, has been up and down through drug decision house. So he is emotionally, mentally lost. Because he cannot detect from looking at his mother in the state that you call it. My child is good behavior, and she did this, and she did classes. And great, but my mom didn't have an option to take the class with her. My mom didn't have an option of life. It was stolen. And because of Katrina, we didn't even get fair justice. So I asked, without being too long with it. And me myself, not having to see my mother, being able to be one, take our name and do something greater, becoming a Togo captain in the ship channel, right? I dedicated myself to being the strongest point of this family because of the strongest thing that I've taken. So when you consider this, I want you to consider this, please. No amount of time can account for taking another person's life. 30 years, 35 years, somebody who was just innocent, no criminal background. They didn't want any trouble, wanted to love everybody around them, stole their blessings from everyone that was talking. So, we talked about freedom. Where's my mom? What was her chance? What was her opportunity? Why can't she be up here thinking for herself? Not because of this woman having pain.
We also have Shalonda McIntosh, victim's sister, who will speak.
I'm also a life woman. And the loss of my sister over the last 20 years has been unbearable. And I thought that I was over it. And I thought that I could heal from it and move on. But as this case has reclaimed or came upon again, I'm not over it. I'm trying to forgive, but I can't. For her to stick, for the offender to stick and claim that she had nothing to do with what happened to my sister is very, very unbelievable. The case, the evidence was lost, so we can't really prove what hand that she had in it. But she had enough hand in it to take my sister away from us. My sister was loving, and regardless of what was in the case, she was a loving person, would give the shirt off her back. And I just don't feel as if Teresa has presented enough remorse, and I'm seeing on the screen, to be released back into this community. She's smiling, and I don't see anything right now worth smiling about. This is my sister, this is a family member, and we will never get back again. She has grandchildren that she never met. Nieces and nephews and cousins. You name it. She would have been a pillar to them. And people go through things in life, drugs, whatever. Everybody in this courtroom has a family member that has been in a situation where they didn't want to be. That does not give anybody the right to take a life. For that reason and that reason only, I wish and I will hope that you guys make a decision that she stay in there and do the rest of her time. I'm not going to be long-winded, but I thank you for hearing me.
You will. All right. We also have Latanya McMillan.
Thank you guys for hearing me today. I grew up down the street from Miss Tina. That's what we called her in the neighborhood, Miss Tina. Miss Tina had the house in the corner that was custom built with custom drapes. And you took your shoes off when you went in her house. Miss Tina had the shirt away that said Mighty Mike's mom. And she ran up and down the sidelines at her son's football game when he played Little League. She loved Denzel. He was her pride and joy. And she was also, like Denzel stated, all they had. She was the mother and the father. And she was the only one that could keep her son Mike in line. And I'm here to tell you that since she has left that spiral, and it is a direct result of this incident. He has a little girl that looks just like his mother. He has to look her in the face, see his mother every time he sees that child. Taking her away didn't just end her life, it ended his in a way too. It took away Mike's mom. It took away little Denzel's mom. It took away ours, this Tina. The teen mom. The biggest cheerleader at the Little League field. The woman with the big smile and the loud voice that was small in stature, but big in personality. It took it away. And I came here today not knowing how I felt about this person being released, because I understand that 20 years is a long time. And I believe in forgiveness and I believe in reforming all those things. But what I did not hear her say one time was that she was sorry. Not once. In her opening statement, she said she admitted that she gave the weapons. She never said that she was sorry. She begged for the person to come over. She coached them on the years that she started the program. It all sounds very rehearsed, but even in her rehearsal, she couldn't rehearse that she was sorry. And for that, I hope that you guys will find that she has no remorse. And until she be remorseful, there will be no justice, no real justice anyway. And the only thing that you guys can do to help ensure that there is legal justice is to keep her behind this bar. If she's in St. Tammany Parish, her family members will come and see her and visit her if they care enough to. We can't go see Miss Nina again. She's got a ring on her finger, so she's probably married. Miss Nina can't live that life. She'll never see her son get married. Her family can still go see her in St. Tammany Parish. And until she can find remorse, she needs to stay right there. Thank you.
Thank you. All right, that's the end of the people who wish to testify. We also have opposition, though, from the district attorney's office, from the sheriff's office, and from the attorney general's office. So I'm going to begin the questioning, and I have one of the same questions that I think the victim's family has. In the beginning, you told us that you provided the weapon, and that was the extent of it. However, in some of the reports that I've read, it says that you eventually admitted that you did it, that you were the one who did it. So did you do it or did you not do it? That's the question.
Yes, sir, I did. I did, sir.
Okay. That was the only question I had. Anybody else have a question?
How old were you when this happened?
24, sir.
And how much treatment have you had since you've been
I
in
had a
jail?
lot of treatment since I've been in jail, the whole 20 years. I've been
Okay.
in a lot of classes.
Substance abuse?
I've been in substance abuse. I've been in Celebrate Recovery. I was in reentry. I was in forklifting. I was in OSHA safety trade and money management. No, sir. No, ma'am.
Are you taking any classes right now?
Yes, sir.
Which one are you in?
GED, sir.
Okay, how much longer you got on your GED?
I don't know, sir.
Can I speak on the GED for just a second?
Sure.
She has been in GED in adult ed since she got here. When she got here, she could barely read or write. We started off with Hooked on Phonics. So now she has progressed. She has taken the high set before, but did not pass. Just the fact that she was able to read it well enough to take it was monumental to us. She did complete the literacy portion. As far as getting the high set, she may have plateaued where she's at, but she is functional now from where she was.
All right, next, where did you get the iron? The iron was just laying around? You had the iron with you? Where did it
It
come
was
from?
just laying around, sir.
And the knife came from the kitchen?
Yes, sir.
Okay, I have no further questions.
Were you doing drugs at the time?
Yes, sir.
How long had you been on drugs?
I was on the drug from 21 to 24.
Okay.
What was the fight about?
It was about money.
All right. Any more questions?
No.
All right, all the questions have been asked. It's time to vote. So I'm assigned the case. I'm going to vote first. And I am going to vote to deny parole based on the violent nature of the crime, the family opposition, law enforcement opposition, and lack of remorse.
That's right.
Mr. Freeman.
Okay, you're doing well. You're picking up some stuff. You need to keep working on your GED. You just need to do more time. I mean, 20 years for taking a person's life is just, it's not enough at this time, but I do want you to keep your head up and keep doing well. But my vote today is to deny.
Mr. Tillis?
My vote is also to deny, and you're doing well. Keep doing what you need to do. And I do see a little remorsefulness in it with you, but keep trying.
All right, Ms. Hopkins, today your parole has been denied. This concludes our business with Ms. Hopkins at the Transition Center.
Denied.
Okay, friends. Whoa, loud. That is where we'll leave it for today with our loud kitten friends as we say goodbye. Hope you all had fun. Please do join us tonight, 8 p.m. Eastern, 5 p.m. Pacific, right here on this channel for Sidebar. Again, we're going to discuss the role of AI in the writing of police reports. Our initial thoughts, I think, are it's not everything we would hope it would be, but we'll hash it out. It should be a wonderful discussion, a chance for us all to learn something and take a different look at the legal system from what we normally cover here on the channel, so it should be good. But again, that's 8 p.m. Eastern, 5 p.m. Pacific tonight. Do check out Michael Groff and his channel. We have links that we put in the chat earlier, and it's also linked in the description to this video. And we'll, if nothing else, see you tomorrow, 10 a.m. Eastern, 7 a.m. Pacific, half an hour early for channel members. Appreciate all of you. It's been fun. Hopefully we'll see you this evening. In the meantime, take care. God bless.